Ahmadinejad's presidency and their role, but I would be
one member to join me. Thank you.
Election or return it, because in the last months and especially the last weeks, they've been very strongly supportive of Ahmadinejad. So, if indeed the Guardian Council again.
Good morning. One tries. Welcome to the Committee of the Whole, of the whole chairman of the Senate Committee on Public Safety. We do believe a member is on the way, and again, we appreciate and recognize the fact that I think almost all of the committee members are serving simultaneously on another committee. Assemblyman Jeffries, you were the first here, so we will take your bill first. Just a little bit of housekeeping. Item number 8, AB 960 by Assemblyman Perez, has been pulled from today's calendar by the author. Otherwise, the agenda is whole. Welcome, Assemblyman.
Thank you. Thank you.
Your AB 27, our item number 2.
Yes. AB 27, I don't know if that will be closer or not. AB 27 will extend the sunset date for the monetary penalties for aggravated arson. This bill is identical to AB 1995 of last year that I carried. That bill made it all the way through to a Senate approps last year as well. The monetary damages or the monetary damage penalties which trigger aggravated arson will sunset on January 1st, 2010. This bill will extend that sunset another 5 years to 2014. It also adjusts the penalties upwards for inflation from $5.6 million to $6.5 million, and there has been no opposition to date. And I would respectfully ask for an aye vote when you have enough. Thank you.
Thank you, Mr. Jeffries. In support.
Tim Yarian, representing the Association for Los Angeles Deputy Sheriffs, the Riverside Sheriffs Association, and the Orange County Professional Firefighters Association. We're in support of the bill. Given the enormous damages and loss of life caused by arsonists in Southern California, we think that's an appropriate response. Thank you.
Thank you, Mr. Yarian.
Good morning, Mr. Chair and members. Dorothy Johnson with the League of California Cities, and we're in support for the reasons previously mentioned. Thank you.
Thank you, Ms. Johnson.
Good morning, Mr. Chair and members. Corey Salzillo on behalf of the California District Attorneys Association. We're in support.
Thank you, sir. Anyone else in support of AB 27? I don't believe there is any opposition, but we'll forward for that opportunity. Any opposition? And we welcome my Vice Chair, Senator Benoit. Any questions from the committee? If not, as soon as we establish our quorum, Mr. Jeffries, we'll be pleased to take up your bill.
Thank you. Thank you again. Thank you.
And our next author is Assemblyman Portantino, item number 4, AB 169.
Mr. Chair, I'm going to defer to Mr. Amiano, who wants to run back to committee.
Well, we will do that. Mr. Amiano, serving on public safety as we speak. You have one bill, that is your AB 358, dealing with criminal procedure, our item number 6.
Yes, sir. Thank you, and thank you, and also thank my colleague from New Jersey of Italian heritage, Mr. Portantino, for being very gracious and much appreciated.
You guys stick together.
Yeah, we stick together. AB 358 is a measure that amends existing law, Penal Code 1000, granting courts greater discretion to determine whether a defendant charged with crimes related to the use of a controlled substance should be eligible for deferred entry of judgment and directed into a drug diversion program. AB 358 simply authorizes a court at a defendant's request to review the prosecuting attorney's determination of ineligibility for a deferred entry of judgment, and authorizes the court to make the final determination as to the eligibility. Currently, the DA can either determine that a first offender with no priors could be deferred or not, and there is an appeal process, but it's very expensive and takes a while. So this would simply state that the defendant can appeal to the judge to determine whether or not he or she goes to diversion, and the judge would have to use the same criteria as the prosecutor. And this bill is sponsored by the California Attorneys for Criminal Justice and supported by the Public Defenders Association. I have with me today Mr. Ignacio Hernandez testifying in support.
Thank you, Mr. Almiano.
Thank you, Mr. Chair. Members, Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice. We are the sponsors. This bill is really a procedural change. The PC 1000 Deferred Entry of Judgment program has been in place for quite a while, and there are several pieces already which require the court to hear information about someone's eligibility. The DA looks at the file, looks at the 6 statutory requirements, and makes a determination of eligibility or ineligibility. The DA then has to put it on the record in front of the judge why someone is not eligible. However, judges, even hearing that information, have no role and are prohibited from making any kind of finding or assessment of whether or not that determination is accurate or not, even if there's a disagreement between the defense and the DA. I've handled some of these cases, and it's really kind of a strange process to sit in front of the judge to argue that there's a disagreement on the statutory eligibility, and the judge sitting up there and he or she saying, well, I can't even look at the file. I have an opinion on this, but I can't say anything. You have to wait till a post-judgment appeal and go through a long appellate process. This is simply an additional step of review. It doesn't expand criteria. It doesn't expand eligibility. And it's way actually court efficiency would be served by having the judge look at it on the spot when he or she's already hearing the information. It's a very narrow program. It's a very rigorous program. It could extend out to up to 3 years of someone having to stay out of trouble to actually satisfy all of the requirements. So we ask for your support.
So narrowly crafted, so just for drug.
Yes, it's just for drug offenses, for first offenses, very, very narrow category of individuals.
What is the history with deferred entry of judgment that puts all of this in the hands of the prosecutor?
That's how it was written. The DAs thought that initially the way it was set up is it was going to be a discussion between the defense and the DAs to look at these files to figure out which cases actually need to move forward, and it was kind of a back and forth. And it's worked to some degree, but there have been problems throughout where there are disagreements. The idea was that the criteria is so narrow that there was little room for interpretation for DAs, so they thought just as far as efficiency, it was better just have the DAs make that determination. However, what we have found over the years is that there are a handful of cases, small percentage of cases, which there are disagreements. For example, if the underlying case involves violence or threat of violence, someone is ineligible for deferred entry of judgment. Even though someone is not charged with a violent offense, occasionally prosecutors say, well, there's kind of a hint of violence here, and the defendants would disagree with that, and there's just simply no neutral arbiter of that issue to be presented and have it resolved. This is just a way to say, no offense to the DAs, but they are in a tough role because they are both the prosecutor and have to make this kind of neutral determination. So when we have this backstop, by inserting this backstop, then we can ensure that the decisions are accurate, and whoever is eligible will go into deferred entry judgment. Whoever is ineligible will then go through the regular process.
Right. Thank you, Mr. Hernandez. Others in support?
David Warren, Taxpayers for Improving Public Safety. We strongly believe broadening the discretion of the court is to the benefit of the entire judicial process. Thank you.
Thank you, Mr. Warren.
My name is Heidi Strupp. I'm representing Legal Services for Prisoners with Children, and we're in support of this bill.
Thank you for your witness today. Anyone else in support? In opposition?
Mr. Chair and members, Corey Salzillo on behalf of the California District Attorneys Association. I just want to go over a couple of things that Mr. Hernandez said. We are in opposition to the bill, I think, frankly, because we feel it's unnecessary. We're not convinced that there's a problem with the existing process. I know Mr. Hernandez talked about a few cases that he's personally handled, but in terms of, changing the whole law just to accommodate a couple of cases, I think that's a little bit of overkill. As Mr. Hernandez says, 4 of the 6 criteria are purely determined from looking at the record. It's an issue of eligibility and not amenability, and so it's more of a checkbox type of determination. As an officer of the court, the DA has no incentive to be less than honest when they're making this determination. And given the recent amendments where the determination that the judge makes is exactly the same as the one that the district attorney makes, we think it's duplicative. Thank you.
Thank you. Anyone else in opposition? Any questions from the committee? We almost have a quorum, so as soon as we do, Assemblyman, if you'd like to make any closing statement.
I just would very respectfully ask you for an aye vote.
Thank you.
Thank you.
Take that up as soon as we get our quorum.
Thank you.
Has to go before Mr. Portantino. Gone and filed order, but Mr. Portantino did defer.
Right.
Assemblyman Amiata.
Mr. Portantino, you are next. There's been a request by Mr. Nava, who's in the back of the room. Mr. Nava, Mr. Portantino's, I trust you, is going to go much more quickly than yours, and he's already deferred once to Mr. Amiano, so welcome.
Thank you, Mr. Chair. And I will be very quick.
So, everyone, we're on item number 4, Assemblyman Portantino's AB 169.
Thank you, Mr. Chair. Last year, the legislature passed AB 2737 to permit court-ordered blood testing of an arrestee when a peace officer, firefighter, or emergency medical personnel acting within the normal scope of their duties suffer a blood-borne pathogen exposure from that arrestee. That bill, AB 2737, was unopposed and passed both houses almost unanimously. I've introduced AB 169 to include custodial officers, custodial assistants, and non-sworn uniform employees who have care or control of inmates in detention facilities to be included in the class of employees who can request court-ordered testing of an arrestee. The bill passed the Assembly 475-0. There is no opposition, and I respectfully ask for an aye vote.
Thank you, sir. Those in support?
Jim votes on behalf of the Santa Ana Police Officers Association and the LA County Professional Police Officers Association, both of whom have members in this category, and also the California Fraternal Order of Police and Long Beach POA, who have associate members in this category. In strong support.
Thank you, Mr. Votes.
Thank you, sir.
In support. Anyone else? I don't believe there's any opposition, but if there is, please step forward. And any questions or comments from the committee? Very straightforward bill. Good public safety bill.
Thank you.
If you'd like to close.
I respectfully ask for an aye vote when you have a quorum.
Thank you, Mr. Portantino.
Thank you.
Mr. Nava. AB 61, our item number 3. Welcome.
Thank you.
Please begin.
Mr. Chair and Senators, I'm here to present Assembly Bill 61, Deferred Entry of Judgment. AB 61 will prohibit authorities from granting deferred entry of judgment to juveniles who have committed sex offenses. Deferred entry of judgment was created to provide the courts a rehabilitative option for some juveniles who commit low-level felonies or who should perhaps be provided with a second chance. Under this process, instead of these offenders proceeding through the normal juvenile court, they can admit guilt to their crime and be sent to and dealt with directly in probation. Currently, the only felonies that are exempted from qualifying a juvenile for the Deferred Entry of Judgment program are the 707(b) crimes. Those crimes that are so heinous, the juveniles can be tried as adults. There are still numerous sex crimes that a juvenile can commit right now, be granted probation, and then have the crime expunged. Crimes that are still eligible for this program include rape, sodomy, lewd and lascivious acts with a child, and oral copulation. Subsequently, deferred judgment can be used, in my opinion, to launder egregious sex crimes from a juvenile's record. It is unacceptable that any sex crime of this nature be swept under the rug. This measure will cease the practice of sending juveniles straight to a probation officer if they have committed egregious sex crimes. The list of crimes that we are adding are sexual violent predator predicate crimes that are not already on the 707(b) list. I respectfully ask for an aye vote on this measure sponsored by PORAC and supported by the California District Attorneys Association, the Los Angeles County District Attorney, and Crime Victims United.
Thank you very much. Witnesses in support.
Good morning, Mr. Chair and committee. My name is Ron Cottingham. I'm president of the Peace Officers Research Association of California, and it was through our members the probation associations that brought this to our attention, they felt that this was an egregious loophole when Prop 21 was passed, that it excluded these sex crimes from being considered on the juvenile cases. I mean, the crux of it is that these are sex crimes. These are not sexual in nature. These are crimes of violence. I worked for the San Diego Sheriff's Department. I still work for the San Diego Sheriff's Department, but I was in charge of our sex crimes unit for about 10 years and handled many juvenile cases, and I can tell you that juvenile offenders are just as egregious as adult offenders when you get to sex crimes, and they see this as an act of violence and an act of control. To have them go into deferred entry of judgment where they are on light supervision for parole or no supervision, and their record can be expunged after 12 months under supervision to up to a maximum of 36 months under supervision, is not the way to go, because we know that 50% of adult offenders also were offenders as a child or as a juvenile, and I really don't refer to them as child when they commit these types of acts. We feel that this needs to be handled in a much better fashion. They need to come under the scrutiny of the court, to wit that you can actually have a juvenile who commits the offense at age 14. After 36 months of probation under DEJ, they would be 17 years old. They would be clear, no longer under court supervision, and their record would automatically be expunged. If they are made wards of the court, they would actually have to petition the court to be expunged. They'd be a ward and under the control of the juvenile court until age 21. And to get that record expunged, they would have to prove rehabilitation to the court, which is a much better system than the DEJ system. For these reasons, we urge your aye vote in passing this bill. Thank you.
Thank you, Mr. Cunningham.
Hi, good morning. Dawn Kepke on behalf of Crime Victims United of California in support of AB 61. CVUC is highly concerned about the ability under the DEJ process for these crimes in this bill to be able just to have those charges dismissed and not be reflected on the individual's record going forward, particularly when we talk about trying to identify a pattern of crime, of increasing persistency in crime with that individual. Without having that information before us in that individual's record, we're concerned that we won't be able to identify those individuals who we may have an ongoing problem with. And furthermore, having victims have their cases essentially dismissed and not be reflected ongoing is of concern to victims and the victim community. Thank you.
Ms. Kepke. Others in support of Assemblyman Nava's bill?
Mr. Chairman, members, Corey Salzillo on behalf of the California District Attorneys Association, we're in support. I just briefly note that the offenses that are included or excluded from DEJ under this bill are different elements of crimes that are basically included under as 707B offenses. Not all of these, but most of these: rape, sodomy, lewd acts, and oral copulation. The forcible elements of those crimes are included under 707B. This would merely expand that bill to include they're not non-forcible, but the ones that aren't considered forcible today.
Thank you, Mr. Salzillo. Others in support?
Mr. Chair, members of the committee, my name is Jim Frayne, representing the Deputy Sheriff's Association of Orange County, Sacramento, Anaheim Police Association, California Coalition of Probation Organizations, Fraternal Order of Police, Sacramento Chapter. We strongly support this bill. The major provisions of this bill, as was relayed by the District Attorneys Association, is to add additional crimes to exclude deferred entry of judgments, such as rape, incest, oral copulation, lewd conduct with children under 14 years of age. I can't see where those shouldn't be excluded from the entry of deferred judgments. And in the interest of justice to protect our children, we urge an aye vote. Thank you.
Thank you, sir. Others in support?
Mr. Chairman, Senators, I'm Jim Votes on behalf of the LA County Professional Peace Officers Association, the Police Officers Associations from both Long Beach and Santa Ana, and the California Fraternal Order of Police, all in support.
Thank you, sir.
Tim Yarian, representing the Association for Los Angeles Deputy Sheriffs and the Riverside Sheriffs Association, in support of the bill.
Ms. Yarian.
Karen Pank on behalf of the California State Sheriffs Association, in support of the bill.
Ms. Pank. Anyone else in support of Assemblyman Nava's bill? Anyone here would like to speak in opposition?
I recognize a quorum.
And as you're stepping forward, we're going to establish our quorum. Please call the roll.
Giuliano?
Here.
Bernard? White?
Here.
Dio? Hancock?
Here.
Huff?
Here.
Steinberg? Wright.
We have our quorum. Those in opposition?
David Warren, Taxpayers for Improving Public Safety. The purpose of the juvenile justice system is to allow juveniles to change as they grow and mature. There's no doubt that there is study after study which has confirmed that juveniles do not have the same ability to determine the correctness or the criminality of their conduct until at these young ages. To allow the individual to demonstrate rehabilitation to the probation officer is much easier, because proving a negative to a court judge, i.e., I am rehabilitated, I will not do this again, is a very difficult hurdle to overcome. And for this reason, we strongly oppose this bill. Thank you.
Thank you, Mr. Warren.
My name is Heidi Strupp, representing Legal Services for Prisoners with Children. We oppose this bill because we think we should be expanding deferred entry of judgment and not limiting it. Broader than that, we encourage the state legislature to recognize we already have, I would believe, enough laws on the books that criminalize and penalize people convicted of these types of crimes, and that I would encourage us to consider non-punitive other approaches to addressing this very harmful act. Thank you.
Thank you. For your testimony, anyone else in opposition? Mr. Hava, aside from the horrific nature of the listed crimes that would be exempted from the deferred entry of judgment in your bill and the real pain and suffering they cause people, I have to tell you, I find this intellectually a fascinating issue you have come upon. I did support it in the Assembly. Not in a policy committee, but on the floor. So I'm having a much closer look at it now, and I think Proposition 9, which I'll get to in a moment, I think has changed the equation just a little bit. But it's fascinating in a number of ways. First of all, of course, as we usually do in this committee, we would ask to really identify the problem that the bill is trying to fix. So my first question would be to district attorneys, because clearly the only way a deferred entry of judgment even occurs is with the blessing of a district attorney. So if the district attorneys could tell us, since this is all in your hands right now, what's the problem?
Mr. Chair, I think the problem is that there are some fairly serious crimes that are not included on the list of crimes that from which a juvenile is exempted. And in looking at this bill from a policy standpoint, I can't tell you that our legislative committee contemplated that question, the removal of discretion versus whether or not this should be charged. But there wasn't a whole lot of debate as to the propriety of the policy that was being attempted in this bill. So I can't tell you that we want our discretion removed, but I think as a policy we agree that these are some pretty bad things, and that it's okay to say these folks cannot go into DEJ.
Did the District Attorneys Association have any hand in writing Proposition 21?
Proposition 21? Yes, we did.
So you wrote it, and you exempted didn't exempt the very things that you're now saying need to be exempted.
I was not involved in the process, but my sense is that when they were drafting the measure, that there was some thought process that, in order to make it palatable, that maybe we look at, some of the most heinous of crimes to take away at this point. And, things can change, as you noted. You looked at it in the Assembly.
Since the passage of Prop 21, can you tell us how often is the case that you've run into a problem that having this discretion has somehow harmed your situation?
I can't tell you that I have a number of cases that we've run into that situation, but I think as a policy we would agree that it's okay to exempt things.
So you can't even tell me one?
I'm not in the courtroom. We don't collect those statistics on that sort of thing,
okay.
And it's not a sponsored
bill. But you come to this committee often enough to know that
Absolutely.
If we're trying to fix a problem, you should be prepared to tell us these are the situations where this has happened and we need to fix it. Now, our analysis points out that when Senator Ashburn first introduced this bill, I think it was 2005, that it was due to a specific case. The analysis reads, these bills arise from a single Kern County case in which the prosecutor, against the victim's family wishes, placed a juvenile sex offender in the DEJ program in lieu of formal prosecution. So it was one of these crimes. Now, this was one crime, and you can't even name another, but I have to say, just a moment ago, when testifying against Assemblyman Amiano's bill, you actually said no need to change the law for a couple of cases. So now you can't even give me one case, and you want to change the law which gives you full control of the situation. So you're not making a strong case as why we should be changing this law. Now, the other change that has occurred since Prop 9 addresses the very situation in Kern County, because Prop 9 now requires that the victim's family must be consulted before the DA can do this. So I think that's the loophole that got closed that was important for this situation in Kern County. But if you've got the controls in the hands of the district attorney, and the court has to agree, and the juvenile, let's not forget, we're talking about a juvenile, and the juvenile has to step forward to say, I did this horrible thing. Add to that, you have to get the permission of the crime victim's family to say, in this one circumstance, I think it's okay. I don't see where there's a problem yet.
I'm not sure that I read Prop 9 the same way that you do. I agree that the victim and the victim's family has to be consulted. I'm not sure that Prop 9 requires an affirmative sign-off on behalf of the victim in order to allow the district attorney to proceed. So you're correct in that the victim is part of the process, but I don't believe it's the case.
Okay, and in the real world, a district attorney, per Prop 9, is going to go to the victim and confer, minimally confer. And the victim says, hell no. How dare you even bring that suggestion to my family? We're offended. Tell me what you think the DA is going to do.
I imagine the DA is going to take that into consideration with the number of other factors they take into consideration.
I think they probably would.
But I'm not sure that I wouldn't characterize it as a controlling factor necessarily in every single case.
Okay. But again, you can't give me one circumstance where a DA who has the discretion to use DEJ has had a problem in using that discretion that you now need to take the discretion away. Give me just one case.
I'm sorry, we don't collect those sorts of statistics, even in advance of a bill like this. I mean, I don't want to say that it's just because we're not the sponsors of the bill, but
And do you still agree there's no need to change the law for a couple of cases? You said that just 5 minutes ago.
I did in terms of the PC 1000 situation with the discretion. The line prosecutors who every day deal with these cases had no concerns about removing the discretion, as you put it, from their hands. I mean, they're the ones that go into the courtroom and have to make that decision with the victims in mind and with their consultation. And so I think that if that was going to outweigh the policy that the bill proffers, I think that would have come up, and it just didn't. I'm sorry. I apologize for not having a list of cases. And
I'm just looking for one.
No, I understand, but there's anyway.
Ms. Koepke, I should allow you to respond. I'm the one who invoked your name.
Thank you. We would just agree with the DA's association that while Prop 9 does provide for victims' impact statements and to be consulted in these cases, it is our interpretation that that is not an overriding decision point. That they don't have the final word when it comes to making that decision. It's just a mere providing that.
Sure.
That said, we can't necessarily say that that doesn't provide some heavy burden for the DAs, but certainly we just want to make sure that it's clear that we do not, as the victim community, believe that we have the final say when it comes to these sentencing decisions or other decisions like that.
Getting back to the real world, and if you've got a single case, in fact, anyone in the room have a single example? I'm just looking for one so we can talk about it. Let's say there is one. I can't even imagine what the circumstances are because, again, the control's in the hand of the district attorney. And we're talking about some rather unpleasant subjects: rape, oral copulation, sexual penetration or sodomy, incest, sodomy, penetration. It just goes on and on. Willful and lewd lascivious actions. Awful things. For some reason, for some reason, which no one in the room can even share with me, a DA in these cases wants to move forward with deferred entry of judgment. And the court, for that same reason, whatever it is, though we don't know what it is because no one can tell me what it is, agrees. For Prop 9, they now have to come to one of your members. And your member says, I don't think so. Please be respectful.
Right.
Rape, oral copulation, sexual penetration, sodomy. You said it would be a heavy burden on the DA. Can you, in your wildest imagination, since we can't even come up with the reason why we're having this conversation, you tell the DA and the court, please don't do this. Reporters are listening. What do you think is going to happen?
Right. I think from our standpoint on this particular bill, the key point of this with regard to DEJ is the provision that allows for those charges in that case to be dismissed and essentially expunged from that individual's record.
Again, only with the blessing of the DA, the court, and most likely the victim. If the victim said, listen, I don't mind the DEJ, I just don't like the concept of the record being expunged. I do not give you my blessing, Mr. DA.
I guess the concern is that we don't think that there's ability to bifurcate the two. And so our thought is in these particular cases, we think it is critical that that information may be maintained on the record. And so essentially those particular instances should not be allowed in any case to be expunged from the record, because we would argue that those particular crimes are so serious and potentially violent that going forward not having those on their record, even if there was a way to figure out some other probationary or other type of options available to that individual, our primary concern is being able to have that particular crime expunged from the record. And we're concerned that you can't, that under the way the current law is that you can't bifurcate the two. And going forward, we need to make sure that we have all the information we can on a particular individual, so that if there is a progressing pattern of violence, of criminal activity, that we make sure that we have all the information available to be able to make decisions in the future, if there is that escalating violence. We certainly don't argue that the system is set up to be able to help turn these kids' lives around, or at least it should be. We don't argue with that, but I think really the point that this comes down to for us is just not allowing these particular crimes to be expunged from the record in any situation.
And I hope you did not misunderstand me. No one is even suggesting that there be a bifurcation. It's just that the two go together.
Right.
And you couldn't separate them.
Right.
You wouldn't separate them. But in the case,
right.
And again, we're looking for the one case.
Right.
This is certainly making the threshold, the hurdle, even higher now that the victim has to be consulted as a result of Prop 9. So without Prop 9, we can't come up with one case. With Prop 9,
I understand.
Yeah. All right.
Mr. Chair.
Mr. Cunningham.
Respectfully, I would tell you that the conversation you're talking about between the DA and the victim does not occur in the courtroom. It occurs in the privacy of their office, and a lot of times the court really isn't even advised of that, and I've been through that process myself. Even when the investigating officers meet with the DA or the deputy DA, whoever's going to try the case, and pleads what they would like to have happen in court, I'm not going to say it doesn't fall on deaf ears, but a lot of times they feel like they need to go forward with the best information that they have and make a decision based on their own consult. And a lot of times the cries of the victim, no matter how anguished, or the cries of law enforcement, sometimes do go unheeded, and that's a fact of the matter. I can't name you one case, all right, but I do know that this was brought to us not by one probation officer. We have over 30 probation associations that belong to PORAC. It was brought by those associations because of the things that they see in the field after adjudication, after the person is put on DEJ, and the problems that they have, because the most you can do sometimes with these juveniles on DEJ is impose a curfew restriction on them. There's not a lot of restrictions that are placed on them when they are under probation on DEJ. They are not under the adjudication of the court. If they mess up, they cannot be brought back in and put back into custody. You need to make a new case on them. What we see from a practical standpoint is that when we go forward, and they have passed either their 12-month or their 36-month probation, and their record is expunged just automatically without doing anything else except maybe having a curfew restriction, and they reoffend, we can't pull those records up again. And as we have determined, 50% of adult offenders were offenders as juveniles. I had many of these juveniles on my own caseloads when I was handling these cases in San Diego. And they, as you might want to refer to them as children, but the people that do these offenses are not children. This is not a sex act to them. This is an act of violence. It is an act of dominance and an act of control.
In which case they're already exempted. So let's take that out of the conversation. Anything that hints of violence is already exempted.
Okay, but even okay, we're talking about when they are specifically charged with rape by force, sodomy by force, oral copulation, or child molest by force. That's a specific section in itself. What we are adding is the sections of rape, the sections of child abuse, and the sections of sodomy that don't specifically allude to a force element, because they still are acts of violence. And that's what we consider. So that, again, if they are made wards of the court and kept under the court jurisdiction up until age 21, not dropped at age 16 or 17, depending on the age when they committed the violation and when the 36 months ends, then we have a better handle on them. If they have to prove rehabilitation, which is very difficult for a sexual offender to actually be really rehabilitated. Again, my many years of working sex crimes, I can tell you that even though they can reoffend while they are in counseling, and we've seen that happen. So I cannot name you one cases, but I know that our probation people have brought us anecdotally many incidences where they believe that the loophole created in Prop 21 needs to be covered, and that the fix in Prop 9 is not truly the fix that you envision it to be.
Okay. You know I have utmost respect for you, sir, and
yes, sir.
For your probation officers and for all of the law enforcement in this room. But I have to tell you, it's just confounding. If someone could give me, even hypothetically, let's dream something up. I understand no one could bring one to the room today. Let's dream up a circumstance where a juvenile has committed one of these horrific crimes, and the DA, using his or her own discretion, says, in this case, because, please fill in the blank, I'm going to suggest deferred entry of judgment.
Well, let me respond to that. I mean,
please.
Well, let me respond to that because I think what we're talking about here are people with boots on the ground who came to me to say, this is a problem. I'm a probation officer. I am confronted with someone who is engaged in rape, oral copulation, sexual penetration, sodomy of someone who has a mental disorder or who has a developmental or physical disability, and they get deferred entry of judgment.
How many times has that happened since Prop 21 was passed?
Enough times to be a concern to the people that have to enforce the law.
So we know it has happened. We're getting closer. I'm looking for truth. I'm looking for facts.
I didn't bring you this issue.
The DAs tell us how many times the DAs have used their discretion to allow for deferred entry of judgment regarding any of the crimes on Mr. Nava's list. Has it ever been used? And what was the circumstance? I'm trying to get to the idea. What could lead a DA to give such an opportunity to a youth to redeem his or herself? Has it ever been used? Can we document that it's ever been used since the passage of Prop 21? That's probably a good place to start the conversation.
Can we confirm the DEJ has been used?
For any of the crimes listed on Mr. Nava's list, has it ever been used once?
I'm sure it hasn't. I think the case that you spoke. I'm sorry. We just don't keep the statistics on individual cases like that as an association.
And excuse me, I just can't imagine you think that's a defense.
I'm not making an excuse. I'm just telling you I don't have the answer to that. That's okay. I think you referenced the point. I think it was Dillon was the case that was the impetus for the Ashburn bill. I think that meets your example of when, against the victim's protestations, the prosecutor granted DEJ.
So a single case in Kern County, and you just a few minutes ago said there's no need to change the law for a couple of cases, but we've got one. And since then, the reason for the problem in the Kern County case was because the victim's voice was not only ignored but completely overlooked. That has been changed by Prop 9, and you can't give me one other example or reason. I'd be very curious to know what was the reason that even led that DA in Kern County down that path. I'd be curious to know.
I just received a text from a probation officer supervisor in Ventura County, who I've worked with in crafting this bill, and who was very, very concerned about what has been happening with the deferred entry of judgment. And on 288As, which are annoy and molest, he says it is unfortunately frequently granted in Ventura County.
So we've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. And I'm sure law enforcement up and down the state of California is now listening and texting each other, find a case. We found one situation which has a repeated problem, annoying and molesting a child under the age of 18.
That is correct.
Okay. But we can't come up with any of these rape, oral copulation, sexual penetration, or sodomies in all their varying incarnations. So
would you not agree, Mr. Chair, that there are times when the law has to evolve? That if in fact that these offenses were not included in Prop 21, that maybe it's time to put them in?
If you can document a problem. I
don't want to wait for a victim.
Probation officer, that's not a reasonable argument to be making, because then we lock up everybody who even looks at you wrong and throws away the key because you don't want to have a potential victim.
We didn't have those people in this
Getting back
list.
to annoying or molesting a child under the age of 18, I just want to walk this through a little bit.
Yeah.
So we've got a youngster who has been charged with annoying or molesting a child under the age of 18, clearly less egregious than all these other horrific crimes. So then a DA is thinking, well, maybe we want to give this kid a chance. Or also, Mr. Nava, might this be the case? That in annoying or molesting a child under the age of 18, those sound like somewhat subjective accusations, that maybe the DA doesn't have certainty that he or she can prove the case. And rather than go into court and potentially lose, confers with the judge and the victim's family and says, listen, if we can get this kid to admit he did it, then we can save ourselves the risk of losing in court, and we give this kid a chance. Annoying or molesting a child under the age of 18, not a nice thing to do, but not...
It's actually 14. 288A is 14.
Okay. So DAs are, from the probation officer's perspective, abusing a discretion that they currently have, and they want to take that discretion away.
I think that's a fair assessment.
Okay.
And I don't think it's a single instance.
Sure. Well, I'd be happy to have committee members. I'm sorry I've been rattling on so much, but I'm just fascinated that we've got a problem here that no one can, until just now, put a finger on. So maybe we want to consider reducing the bill to annoying or molesting a child under 14, because that's the problem that we've identified, and talk about whether we should take away that discretion, because DAs are just making serious problems with their poor judgment.
It's under 18. It's under 18.
I'd move the bill as is, Mr. Chairman.
647.6 is 18 or 14, Mr. Nama? We've got 18.
Well, 647.6 is 18, but I understand 288A is 14 years of age.
Right. Okay. Very good. Okay. So we've got a motion, which is going to end our discussion. So
does it end the discussion?
We will. I don't have to take up the motion right now, but I think out of respect for the author and for the for Senator Huff, why don't we take up the motion?
Well, I can't vote on the motion because I had some questions.
Well, then we'll take your questions first. Go ahead.
Thank you.
Sure.
Mr. Chair. I have to say I came into the room this morning expecting that I would vote for this bill. I've been following the discussion very, very carefully because one of the things that I do think it's important for us to retain and strengthen is judicial discretion and court discretion in as many ways as possible. It seems to me that we've built a kind of straitjacket in corrections with our repeated passing of initiatives and determine in sentencing, which then results in people being released who maybe shouldn't be, or people not being released who would not be public safety threats anymore. I was and still remain very interested in the point raised by Crime Victims United of identifying a pattern early on that may never come up again, but that if there should be something as a person proceeds through life, it would be useful to know. And I say this in part because we just lived through, in a community that I represent, the horrendous killing of 4 police officers by a young man who from 9th grade should have been identified as a person with severe issues and was always just kind of passed through the system. And so it does seem to me that we want to keep that record. I was told by staff, because I had a question about if the young person is not benefiting from being in the program, the Deferred Entry of Judgment Treatment Program, and I'm told that it can be revoked at any time if you're dealing with somebody that turns out not to benefit from the treatment. So
Mr. Cunningham,
I just have to say
I'm sorry to interrupt for just for a second. So probation officers, if there's a problem with the child while on deferred entry of judgment, your comments had led me to believe that their hands are tied, they can't do anything about it, and that's not the case, or that is the case?
That is the case. According to the Jim Schmidt, who is the main proponent of this bill, who's the supervising probation agent from Ventura County that did text us recently on the issue they have with 288A, the child molest, would have been here today, but he's unavailable. He would have had many more answers than I do. But yes, that is a problem, is that they have very limited control over this juvenile that is placed on DEJ, and he does not come under the jurisdiction of the court. Probation is very light. Treatment may or may not exist, depending on the county, depending on what is available. And at the end of 12 months, if that's what they're given, their record is sealed. The arrest never appears again, and say that he is 13 when that occurs, and now at age 15 he commits the offense again. You have nothing to refer back to as that person being a repeat offender. Or if that person offends now as an adult, you have nothing to refer back to in records to show that this person is a repeat offender. Something that is very important as an investigative tool to law enforcement, as a charging tool to the district attorney's office. So these are a couple of glaring things that are taken off the table with DEJ when a person is granted that.
I'm also unaware of any standards that are established for what constitutes a program. It may not exist. It may just, in fact, be deferred entry of judgment and limited, if any, treatment or conversation with the minor.
And shame on us.
Ms. Hancock, I'm going to give the mic back to you in just a second. I just want to read from the Welfare and Institutions Code 793, Rule of Court 5.800. Okay, well, the summary of it, which is in the analysis, says that, for example, the court is required to schedule a hearing if the court itself, the probation department, or the prosecuting attorney alleges that the minor has not complied with the conditions imposed, or that the conditions are not benefiting the minor, which seems very subjective. So the DA who brought this forward can determine, kid, you're not getting anything out of this, or the probation officer, so that is seemingly inconsistent with what we've heard this morning, or the court. And because a minor in a DEJ case already has admitted the allegations against him, once the DEJ is lifted, the disposition hearing occurs. So the hammer comes down rather quickly if there's even the suggestion that the conditions are not benefiting the minor, much less the minor actually proactively doing something egregious. So I don't understand.
Which section were you reading, sir?
793A.
Could you read 794?
Okay, the standard is in 793A.
Could you read 794, please?
Why don't you go ahead?
Okay. 794 is when a minor is permitted to participate in a deferred entry of judgment procedure, the judge shall impose as a condition of probation the requirement that the minor be subject to warrantless searches of his or her person, residence, or property under his or her control upon the request of a probation officer or peace officer. The court shall also consider whether imposing random drug or alcohol testing or both, including urinalysis, would be an appropriate condition of probation. The judge shall also, when appropriate, require the minor to periodically establish compliance with curfew and school attendance requirements. The court may, in consultation with the probation department, impose any other term of probation authorized by this code that the judge believes would assist in the education, treatment, and rehabilitation of the minor and the prevention of criminal activity. The minor may also be required to pay restitution to the victim or victims pursuant to the provisions of this code.
Sounds like they got their hands around the young kid's neck pretty tight.
But again, this is what we were explaining earlier, is that sometimes all they get is a curfew restriction and required to attend school. Treatment, is, again, they have to be able to pull them back into court to establish some rehabilitation or treatment procedures, and this is something that I guess cannot always be done.
I would agree with Ms. Hancock. Shame on us, but back to your question. I'm sorry.
Well, that was just the clarification that I didn't understand, because I thought it had been said that once you were on this treatment course, it was irrevocable, and I gathered that it is revocable, and there are a variety of things that can be required of the juvenile, and probably a full treatment would cost less than the $239,000 a year it costs us to lock them up. And if it is discretionary on the part of the district attorneys and the court, I'm having trouble with the bill too. Let me say, I would feel differently about a bill that was solely focused on not expunging the record, however, because I believe that we need to be paying attention earlier and longer and breaking patterns in the beginning and knowing when a pattern's occurring.
Thank you. We do have a motion, and if rather than have you close,
yes,
we'll call the roll.
Senators Leno?
The motion is to pass the bill. No.
Leno, no. Benoit? Cedillo? Hancock? No. Hancock, no. Huff? Huff, aye. Steinberg, right.
We'll put the bill on call. So, again, if the real problem, we're not done unless you want to leave.
Oh, I thought we were.
Otherwise, I would have allowed you to close. Again, I want to understand, I don't presuppose that I know how things work on the ground in any way better or even equal to the way many of your witnesses have come forward today, Mr. Nava. But if we do have a problem with DAs abusing their discretion in the cases of annoying or molesting a child, or in some areas, because I really just think it's a stretch of the imagination, and no one has countered that idea yet, that in cases of these horrible, serious sexual crimes, a DA is abusing discretion. That's the part we just have not documented today. And if we ever get there, my mind could begin to change. But since we haven't gotten anywhere close to that, DAs are not using their discretion in rape and oral copulation and sodomy and penetration. But in annoying or molesting a child under 18, I could understand that a DA might, for reasons that have yet to be specified, might use a discretion. Some would say abuse, some would say use. But then, Mr. Cunningham, I get to the point where if that discretion was used, this juvenile, while in DEJ, search and seizure, spontaneous drug tests, all the factors that would suggest this kid's not on the straight and narrow before potentially committing one of these crimes, again, if anything, I think we're just lacking in really formal treatment for these individuals, and maybe that would be a bill I'd like to work with you, Mr. Nava, that we really make sure that we keep these young people from reoffending once they are in DEJ. And I would imagine we have the support of the district attorneys and something like that, too, because no district attorney would want to offer DEJ and then only have to see it boomerang and hit them back in the face later. So we all have vested interests, along with crime victims, who none of us want to see further reoffending. So that's probably one of the weakest links. But otherwise, if we have identified the problem in this one situation, maybe we should be talking about a bill that addresses that situation.
Well, why don't, with the chair's indulgence, if we could have an opportunity to discuss this, you have other authors that you'd like to consider?
Sure. And again, though it's not been asked, I would, without the committee's objection, offer reconsideration so that we can continue the discussion.
Okay.
All right. Thank you for your time.
Thank you.
Somebody's outside. So here's jurisdiction.
Mr. Solario, thank you for your patience.
Thank you, Mr. Chairman. I'm taking a different seat, so I'm not in the hot seat.
You have AB 316, dealing with wrongful convictions, our item number 5 here.
Yes, thank you, Chairman and members. This bill is regarding persons who have been wrongfully convicted, but oftentimes, as you know, face the same obstacles as released felons. In addition, they also experience unique personal and psychological struggles of having spent years in prison for crimes they did not commit. This bill is meant to help them with their struggles as they reenter our society. Specifically, this bill would require the courts to seal the person's record upon the determination that he or she was wrongfully incarcerated, inform the wrongfully convicted person of his options regarding possible compensation and time limits. And the bill would also extend from 6 months to 2 years the deadline to file claims with the California Victims' Compensation and Government Claims Board. It would also extend the statute of limitations to file a claim of malpractice to 2 years after innocence has been established. As you might recall, last year I had a very similar bill that had bipartisan support in both houses. That bill was vetoed by the governor. There was a provision regarding counties providing minimal reentry services to these individuals, and for cost purposes, the governor vetoed that bill. We have taken that piece out of this bill. I do ask for your aye vote, and I also have here with me to testify in support Chris Boscia, former staff member to the California Commission on the Fair Administration of Justice.
Welcome.
Thank you, Senator. Good to see you again. As you know, I worked for former Attorney General John Vandekamp and Dean Ullman at the Commission. The Commission was created by the Senate in 2004 to examine the causes of wrongful convictions and to make recommendations to you, the legislature, and the governor about how to make the system more just, fair, and accurate. And after 2.5 years of meetings and public hearings, we issued a final report last June. The contents of AB 316 were part of our report on remedies for wrongfully convicted people. Essentially, it does 5 things. And these are 5 things that seem abstract, but you have to place yourself in the position of a person who is factually innocent and has been in prison for a long time. These are going to be very important abstractions to pass. The first is to extend the statute of limitations to bring a suit against the person's defense attorney for malpractice. Currently, in order to bring such a suit, the incarcerated person would have to do so before they have a finding of factual innocence. It's hard enough as an incarcerated person to know what malpractice is, let alone to know when you have to bring it. This common sense amendment to through this bill will essentially say that the person has 2 years after their release from prison within which to bring that suit. The second thing it will do is make a finding of factual innocence admissible at a Victims' Compensation Board hearing. It's hard to imagine right now that such a finding by a judge, a district attorney, or a sheriff is not admissible, but in fact it's not. And in the case of Mr. Tennyson, a DA, stipulated to the innocence of the petitioner and in front of the board, and he was denied because such an admission was inadmissible in that hearing. The third thing it will do is require a judge to seal all the records of conviction after a person is found factually innocent. It's currently permissive in the statute, and the case of John Stoll, really tragic case. After he was released, he was one of the Bakersfield dozen who was convicted of child molestation back in Kern County in the 80s. He was released after 20 years and couldn't get a job at Home Depot because his record had not been sealed. And, of course, he said, "Google me, I was exonerated," but Home Depot doesn't want to take that risk, as you can imagine. The fourth thing it'll do is extend the time in which you can file a claim to that victims board from 6 months to 2 years. Senator, people are shell-shocked coming out of prison. A person like John Stoll, after 20 years, just didn't have it together to bring this case for compensation within 6 months. We're just asking for some time. 2 years seems reasonable. And finally, this bill will change the standard for those factually innocent people to prove that they did not commit the crime. The current law says that they cannot negligently or intentionally contribute to the bringing about of their arrest or conviction. That's a very wide standard, and essentially the Attorney General has even acknowledged that a person who made an involuntary false confession or a guilty plea could potentially be denied compensation as a result. So we're changing the standard. The burden, based on some amendments that were recently made, the burden is going to be on the person, the petitioner, to prove by a preponderance of evidence that they did not pervert the justice system by, say, pleading guilty to save a fellow gang member or falsely confessing, et cetera. You understand. So those are the 5 things the bill is going to do. And if Mr. Vandekamp were here, and he wishes he could be, he would remind you that this commission was balanced. It had law enforcement representatives, DAs, public defenders, judges, academics. As a person who witnessed the commission work, hard-fought compromise created these recommendations. This bill is sailing with unanimous support so far, and I hope you would give it the same. Thank you for the opportunity.
Thank you for walking us through the details of the bill, and if you would please share my thanks and appreciation with Mr. Vandekamp for all of your significantly important work that you've done at the commission and for bringing this bill forward.
Thank you, Senator.
Mr. Chairman and members, Francisco Lobaco on behalf of the American Civil Liberties Union. Testimony has indicated the importance of legislation. It is minor but important changes in the statute, and we strongly urge your aye vote and hopefully get a signature this year. Thank you.
I only argue with you on one word, Mr. Lobaco. It's not minor.
Heidi Strepp, representing Legal Services for Prisoners with Children. We think this is a really great bill. Many of our clients are incarcerated survivors convicted for crimes related to defending themselves against abusive partners. These women have been able to come back to court with these cases. Some of them have been found innocent and stand to benefit from this law.
Thank you very much.
David Warren, Taxpayers for Public Safety. We are in support, if amended, as to one issue. The last time I represented a client was 15 years ago in a criminal case. If this legislation goes through as it presently exists, the files which I destroyed 5 years after my retirement, which would no longer be available to allow me to defend myself, would allow a person who 25 years ago I represented is now found factually innocent because of advances in technology which could never have been foreseen to sue me for malpractice. I think that there should be one addition to this legislation, and is to provide that the effective date for the retroactive nature of the extension of the statute of limitations to sue an attorney is as of the date that this matter is approved into law, so that people will then buy a storage facility and keep storing their records until the day they die. Thank you very much.
Thank you, Mr. Warren. Anyone else in support?
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice in support.
Thank you, Mr. Hernandez. Anyone here to speak in opposition to Mr. Solario's bill? Not. Do we have any questions? We have a motion by Senator Hancock. And, Senator, we've identified just some minor technical amendments to be made, so this would be moved as amended. And would you like to close?
As you mentioned, this is not a minor bill. It may only impact 1 to 2 individuals a year, so maybe in that regard. But for those individuals, the changes that would be brought about through these bills would be life-changing in a positive way for them. So I do ask for your support. And as you referenced, your staff read every word and found some grammatical issues as the bill was drafted by Letch Council, and do agree with you in the assessment that we need those technical amendments.
Well, as we're making those amendments, I'd like to be added as a co-author.
Thank you. I would love that. Thank you.
Great. And we'll call the roll.
Senators Leno?
Aye.
Leno, aye. Benoit, Cedillo, Hancock? Aye. Hancock, aye. Huff, Steinberg, Wright?
Bill's on call.
Thank you.
Thank you. So we are looking for a few authors. If they are in earshot, Senator Yee, Assemblyman Miller, Assemblymember Skinner, Assemblymember Torlakson, and Assemblymember Liu. We need you in Senate Public Safety. Welcome, Mr. Torlakson. Great, good to see you. You have AB 1015, our item number 10 before us today.
Thank you. Good morning, Mr. Chairman, members. We're here today on a bill to outlaw the sale of nitrous oxide. We have good witnesses who have helped develop the need for this legislation by gathering facts of the abuse, the increasing abuse, one of the fastest growing areas of substance abuse is in inhalants, and the subset of that is nitrous oxide. The dangers are significant. This is one of those types of chemicals that even upon first use, someone can die. And so we have youth that are being brain damaged. We have youth that are passing out. We have youth that are at risk of death from this substance. And so we've worked with the schools in Los Angeles particularly to identify the cause. We have parents here. We have the good offices of the city attorney, Rocky Delgadillo, who has a unique program to bring his agents and good staff into the schools to do prevention work. And we have someone who is here in terms of health education. We have taken a couple of amendments already, Mr. Chairman, good suggestions of your staff. We look forward to having this hearing and moving legislation forward. I'd like to introduce our witnesses. We first have Diana Del Pozo Mora, who is here with the parent group that led in Boyle Heights and Nightingale School that I visited to bring this bill forward.
Thank you. Welcome to our committee.
Thank you.
And thank you for your good work on this bill.
Yeah. Only because it's
Just get close to the mic.
Sorry.
There you go.
Only because of the importance and because of the true aspect of the fear for the youth. It has done nothing but bring me out to the forefront. I have a 2-year-old third grader now, a 7-year-old, sorry, third grader, who is so easily accessible to the community and what's its environment is. And this is one of those things that's happening in our community, and it's an upbeat. And I have a 20-year-old, so you kind of range where I never had this fear for her, but to have it for my 7-year-old is really scary. So it's really happening in our community. It's something that we're seeing more common than we would like. And I just feel that this kind of action, the AB 1015, would bring such an action for us to have some sort of a law on our side that will be able to help assist in education, prevention, which is one of the most forefront importance for valuable tool for any parent to give to their kids and for the parent as well.
Thank you.
Thank you.
Others in
Thank
support?
you. Next, we have Veronica Dalaba.
Yes, good morning, Mr. Chair, committee. I work as a school safety prosecutor, so I have the benefit of not just of working with the law on the exterior and the traditional prosecution and trying to keep a school safe, but this position's afforded me the ability to look inside the school and work with the community, and that means learning what's happening. And this problem, as I have shared previously, it stemmed from parents talking to me and asking me that their doctors couldn't figure out what the substance abuse problem was, but they felt it was substance abuse related. And we were finding children that had passed out in schools. We were finding children that had been hospitalized. We were learning of deaths and finding nitrous oxide canisters in their vehicles, learning of explosions that had happened in neighborhoods where students had inhaled nitrous oxide, subsequently lit up, and, well, you can imagine the consequences. These were real examples month after month that we're experiencing. And upon further learning, I learned that this isn't just something that is inherent to Los Angeles County. It's not a Southern California problem. It's a nationwide problem. And the studies support that. And sadly, California's usage rate for lifetime use of inhalant abuse is much greater than anything that the rest of the nation is experiencing. And that's highly attributable to some studies as a result of the lack of laws that are there to curtail that access to the youth of this toxic. Thank you.
Thank you very much.
Finally, our third witness is Antonio Roque, who is a health education expert in the district and will underscore why this law is so important from an education value point.
Welcome, Mr. Roque.
Oh, thank you very much, and thank you for allowing us the time to come over here and talk in front of you. For the past 2 years, I've been working specifically with this problem, and being at the central offices, I deal from all the schools, and as you know, LAUSD is the second largest district in the nation, and I deal with parents, teachers, and students alike, providing drug awareness activities and programs, one of those being inhalant abuse education. From the San Fernando Valley all the way to San Pedro, I've had several phone calls, in fact, more than I care to talk about, of students who have been hospitalized, of students who have been taken from the school site to the hospital. There's one case in mind that comes to my mind right now. It's a 7th grader at one of our middle schools who was huffing and had a heart attack as a result of it and was hospitalized. We had to put him in a 6-week detox center. And then after that, he has to go to a 2-year therapy to overcome the addiction. Nitrous oxide specifically is addictive. And we are seeing that nitrous oxide in its canister form, which are commonly known as whippets, are very highly popular with our student population, specifically with males as well. And they're legal. From an education perspective, when I do student presentations and parent workshops, one of the common questions that I get from concerned parents and students is, why is it legal? There are 2 reasons why this has become such a problem. One of them is the availability, and the other one is that it is legal, and they go hand in hand. Also, the perception of risk is low, and so the use is very high. So we feel that if there are laws in the book that will help us in our education effort, to explain to students the reasons why this is illegal is because it is in fact lethal and you can die the first time. So it's a very, very important bill. Thank you very much.
Thank you, sir. Anyone else who'd like to speak in support of Assemblyman Torlikson's bill?
Mr. Chair and members, Corey Sawzilla on behalf of the California District Attorneys Association in support.
Thank you.
Karen Pink on behalf of the California State Sheriff's Association and the Chief Probation Officers of California in support of the bill.
Thank you, Ms. Bank.
Sylvia Solis Shaw on behalf of the City of Los Angeles in support. Thank you.
Thank you, Ms. Solis Shaw. Any other witnesses in support of AB 1015? The name of a well-known club in San Francisco, 1015.
Is it?
Yes. They don't use nitrous oxide for that. Is there any oppositional voice? I don't know that there is. Thank you very much for bringing this forward. You clearly have found a hole in the law that it's illegal for young people to be using this, but it's not illegal for them to obtain it, at least for those who are doing the sale or the provision of. I hope this is an enlightening element to the conversation.
Maybe the Club 1015 in San Francisco.
The
reference.
One concern I have with the bill, that we're taking the somewhat extraordinary step in the case of a business owner who has a prior conviction, that they would actually lose their business license for a year, which is much more severe than selling alcohol to a minor or really any of the other inhalants. So if one had a larger operation and you've got some subordinate salesperson who's done this and got you in trouble the first time, suddenly it happens a second time, I think there should be the burden that the business owner knew or should have known that this person was underage, because maybe that business owner himself, if not, or herself, if not the salesperson, said, you know, it's illegal for me to sell this to you if you are underage. Could I please see some identification? And ID is shown. And so they've done their due diligence. They knew the law. They did what they should have done. But there was a fake ID. Someone looked to be of reasonable age. And now we're going to take the business license away. So I think just putting in that one addition of known or should have known, I think makes the bill all the more stronger.
I appreciate, Mr. Chairman, let me see if the mic's on, I appreciate the idea behind that, and we certainly don't want to have an undue, unfair burden on the business, and I'd like our Deputy City Attorney to help address this. What we were trying to accomplish is something a little more flexible in terms of having the judicial process be able to look at the specifics of a particular case and afford a range instead of a hard $2,500 fine. It's $1 to $2,500, as I understand it, and instead of a a full-on suspension, consideration of 1 day up to a year, with the facts of the case coming before a judge in order to allow that discretion and tailoring to the degree of circumstances that you spoke to. What we were trying to accomplish also is something parallel, not so much as to alcohol sales to minors, but to other deadly kinds of substances like glue and others that have a more life risk threatening value. So if we could just explore this further with our Deputy City Attorney.
Thank you. Let me share this with you. A little background may help. Aside from being a prosecutor, I had the honor of serving as a public defender for quite a number of years, and the benefit of that experience yielded me this. There should always be that opportunity for that due process and that fairness in a judicial setting. I know not one case is always the same, even though maybe the same code section is triggered. Assemblymember Torlikson's office took great care to tailor this bill presently so that that judicial discretion would exist. There is the opportunity, the provision or the risk of a retailer having their business license suspended. There is a range, a period of time as to that, and that is different from the existing somewhat inhalant-related law that's on the books, as you may be aware, which is 381B, which is the toluene or the glue-based statute, which has been on the books for about 20 years. That has it doesn't have a discretionary period of time. It's a 1 year. It's after second-time conviction. This would have a range, and it also has built in so that it would parody 381B, and the effort was made to parody a substance that is similar, and that is the key difference between the alcohol and tobacco statutes that exist, for example, as opposed to the inhalant-related, because in tobacco and alcohol were designed for consumption, and there have been risks with their use shown, whereas you have toluene and you have nitrous oxide, those were never designed for human consumption, and the law has already recognized the lethal dangers with that use.
I have to run to Natural Resources, so I'm about to pass the gavel to Senator Hancock. But what I would want to hear from you, if you could do it as succinctly as possible,
yes,
that given these fines are significantly higher, and I know you're trying to make parity with the inhalants, but alcohol, we know, is very serious, and it's also much more pervasive. So overall, it has a much more greater impact on our communities than the subset who use the inhalants, not diminishing the seriousness. But if we're only giving on first offense community service as a penalty for alcohol sales, again, much broader and pervasive impact on our communities, people driving cars, causing all sorts of havoc, that retailer has to have known or should have known. Why wouldn't we want to put the same in here, since we're going the extra step of saying you could lose your business license, and not even for a week or a month or 2 months can be very devastating to a business owner.
Do you want to speak to that?
So I guess the question I'm asking is, what's the argument against including known or should have known?
Before I do, and I know you're very pressed for time.
No, I don't.
Oh, well, here, the usage rate, if I may, the usage rate as to nitrous oxide is, I believe, with all due respect, much more pervasive than I believe your understanding may be at this time. And I think the studies haven't been very forthcoming in this state as compared to the rest of the state, because there hasn't been that motivation, that requirement to track all the inhalant abuse. In fact,
You're suggesting it's on parity with alcohol?
It's probably more, depending on the age range. Antonio, do you want to share the statistic you have with that?
In terms of inhalant abuse, it is climbing higher and higher. It isn't on parity like you're asking, but it has the potential to become that. And part of the reason is because of the lack of a law. And one of the things that happens with parents and students alike is that perception of risk. Now, this is happening all over. I'm getting calls from San Diego as well because they're seeing the same problem.
So real quickly again, the argument why you could not abide by having the criminal knowledge and intent, which is a part of our jurisprudence.
Right. It's because of the It's because of the nature of this substance, and I had the opportunity to review, for example, the bill analysis in this matter, and I know, for example, there was a matter of Jennings that was referenced.
It dissects Jennings very articulately.
Yes, it does. However, it dissects it after presupposing that alcohol is akin to nitrous oxide abuse. And both of those abuses are very different, and the risks are much greater for this behavior of the nitrous oxide. So therein is the first concern with attempting to parallel the Jennings decision, which is closely tethered to alcohol. I'll also bring to your attention that the Jennings court...
I'm going to have to go cast my votes. Hopefully you're all still here when I get back. I'll actually pass the gavel to my vice chair. My personal desire to support the bill would be to see that small amendment included. So I'll be back. Thank you.
Thank you.
Mr. Vice Chair, how are you, Senator Benoit? one of the things I should cite on the record in response to the chair's question, the national studies show that the use of inhalants is increasing. So in 12th graders, it's about 10%. In 10th graders, it's about 13%. In 8th graders, it's about 16% and growing in terms of the level of abuse. And again, to underscore that a first-time use of nitrous oxide in one of these little canisters for 25 cents, someone can die. A young person can die on a first-time use. So I think I'll let the Vice Chair confer. I think, again, that keeping this in parallel with what we do with glue and other inhalants that are deadly makes some sense. I have another response that I will share in a moment in terms of the Chair's suggested amendment.
Yeah, that's what I would be interested in, Senator Torlakson, while the Vice Chair gets briefed.
So the question is, what are the burdens on the prosecution to prove intent? See, I think proving intent, you can also have sloppy practice, and sloppy practice
yes, and that
isn't
is,
intentional.
and that's exactly what that's why Penal Code Section 380 and 381B do not have that, the T, because they have that intent component, so they're not being used in the field.
I want you to go on record.
Okay.
And see if there's a tweener. I don't know if there's a tweener we can do this. We'll just take it up the way it is.
Senator Torlakson, I apologize for the confusion here. We just finished natural resources, and I had to vote, and the chairs had to go down, so I'm coming in, catching up. I think I'm caught up. You're making your support witnesses, and have you concluded your support witnesses, or do you have further in support before we ask for any opposition?
We've done the witnesses. I think we're in a dialogue on an amendment the chair suggested.
Okay.
And
would you like some more time for that?
I think we could provide some more response and thought to the concern the chair has raised. I want to underscore that we have taken two amendments which we think have allowed for more judicious range of review. One is the elimination of a separate misdemeanor for not checking for the ID when a minor or someone could pass who could be a minor attempts to purchase nitrous oxide. And the second amendment is providing judicial discretion on not only the misdemeanor terms but also the business penalty, providing that a judge will suspend a business license for any period up to a maximum of 1 year. So,
but with discretion.
At the judge's discretion.
With discretion, okay.
Yes. And the concern I have about the chair's amendment in its current form is that apparently, and the deputy attorney will indicate that her knowledge of how statutes that have that language are not used as much in the field because of that language. And I would try to draw the distinction, not being a lawyer myself or a member of this committee with the background, that proving intent to do this is a little different than having sloppy practice and not managing well. I mean, the business owner may say, well, I had the intent not to have this happen, but my clerks keep doing it. But did they provide training? Did they reprimand an employee the first time? And what sanctions internally as a business owner? Maybe the business owner found something happening before law enforcement found it. Does a business owner take responsibility? And so what I understand is that the amendment would make it harder to use this law in terms of prosecution. That's my understanding. I'd like to ask Veronica Dalba once again to comment.
Thank you. I believe that there are two things that are maybe triggered by this. One is the consideration to maybe have an intent component. I don't believe that would be applicable here, nor would it be consistent with the Jennings decision. And again, it returns to the nature of the substance. The Jennings decision itself referenced various cases that said that if there was a significant safety issue where basically there are lives that are at stake, as the analysis in Jennings dealt with subsection C of the alcohol provision laws, it's important to note it's that they wouldn't necessarily need to have the intent referenced in legislation, and I think that would be the place here. Again, tobacco is a product that is designed for consumption. You are not going to experience the same addiction rate nor the risk of death at first-time use that is attributable to nitrous oxide. There is certainly no disputing that. With regard to placing something like that, it's going to placing an intent in the section is going to create in the practice, as Assemblymember Torlakson said, an ineffective statute. It's going to render the statute as ineffective, similar to Section 380, which now makes it against the law to, or 381, which makes it against the law to possess nitrous oxide to use. There's an intent language in there, and unless law enforcement actually observes the huffing or the inhalation, it has no teeth, and so that has also served, yielded no benefit to safeguard those that are more susceptible to the youth.
And again, if trying to understand the chair and any other members of the committee's concern, we don't want to unfairly, close a business for one incident that is, caught on film or turned in as a incident, and that's where we thought the ability to have the judicial hearing, where from 1 day to 1 year can be considered as well as $1 to $2,500 to be considered for the punishment. That's actually a much more discretionary process than currently for glue and some of the other inhalants. And if there's a way, if there's some language where we could get to the chair's concern, which I respect the direction you're heading in terms of unfairly having untoward impact on a business, is there some way to deal with the distinction between management and just intent? Proving intent can be rather difficult compared to...
I don't know that anyone suggested that unless it happened while I was out of the room.
Okay.
Knowing or should have known seems very reasonable. Again, even on first offense, we're talking up to a very significant fine, $2,500. Multiply that times 380%, because that's what the additional penalties on it would be, and up to a year in prison. Up to a year in jail, actually. Sorry.
Jail.
A year in jail. So that is significant. And again, if I were a business owner and said, but we asked for ID, they showed ID, we did what we could.
If I may say something, being on the ground, and I deal with a lot of these schools and parents personally, one-time huffing can cost death and has cost death. And the impact, it's a lot higher than $2,500.
So with all due respect, a child can die from one afternoon of alcohol as well.
Right, and we're seeing that happen over and over. And right now, because there isn't a lot of information out there as it should, as it is for alcohol, we don't really have the numbers that we should have with inhalers.
And that's all going to change with this bill as law. I think things are going to get significantly better, faster, but we just want to put this one protection in.
If we may, Mr. Chairman, a consideration that the sponsor is not comfortable with the amendment right yet, and so what I'd like to do is take a time out or come back and then maybe talk to one of your consultants about the implications of the language you're suggesting.
Okay, that's reasonable.
So instead of taking it up for vote, we'd like to be able to come back if your committee's still going.
We'll just put it on hold for now.
Okay, thank you.
Bill's going nowhere. It's safe here.
Thank you very much.
Thank you all for coming.
Thank you.
You bet. Is she next? Senator Yee, thank you for your patience. Welcome to our committee. You have SCR 40, our item number 1.
Thank you very much, Mr. Chair and members. This is a rather straightforward measure. 80% of those youngsters arrested are involved in alcohol, drug abuse, and many of them are dual diagnosed or sometimes even triple diagnosed. And what this resolution will do is to urge the California Department of Correction and Rehab, and also the Division of Juvenile Justice and county facilities to really join in other states with following a set of parameters about how we should deal with youth. And we should deal with youth in terms of trying to rehabilitate, looking at interventions of mental health services, drug counseling, other kinds of prevention services. And with that, that urgent aye vote.
Thank you. Witnesses in support.
Hi, I'm Sumaya Wahid with the Books Not Bars campaign of the Ella Baker Center for Human Rights out of Oakland, and this bill implements some of the best practices in juvenile justice, and we see huge benefits for the state in terms of public safety, community safety, and lowered crime rates and less money spent on corrections. So we urge an aye vote.
Thanks for your testimony today, and we appreciate the great work of Books Not Bars.
Thank you.
Good morning. Glenn Backus for Drug Policy Alliance. We support policies that would provide that juveniles in the system would have access to effective evidence-based treatments for substance abuse and mental health and other issues, and the other rights enumerated in this resolution. Thank you.
Thank you, Mr. Backus.
Heidi Strupp, representing Legal Services for Prisoners with Children. We support this resolution.
Thank you, Ms. Strupp. Anyone else in support? In opposition? Questions, comments from the committee?
I would move the bill.
We have a motion by Ms. Hancock. If you would like to close.
Thank you very much, and urge an aye vote.
It's a great resolution. We thank you for bringing it forward. Call the roll.
Senators Leno?
Aye.
Leno, aye. Benoit? Cedillo? Hancock?
Aye.
Hancock, aye. Huff? Steinberg? Wright?
We're missing some members. It's on call. Thank you. We see Assemblymen Miller and Garrick. Welcome to the committee. Our item number 7, AB 362.
Thank you.
Issue of and concern dear to all of our hearts.
Yes, absolutely, absolutely. Thank you, Mr. Chairman and members of the Public Safety Committee. AB 362 is in front of you, and this bill is a result of a long process. I want to make sure I acknowledge the committees and the staff and all of the members that worked on this. I think we've been able to address all the concerns. I also want to thank Assemblyman Garrick for working with me. Our bills were designed to address the problem, and I think we've crafted the best of both solutions with all the hard work that we've put in together on this. Currently, it's illegal to vandalize and or infringe upon the free speech of another regardless of motive or intention. However, there continue to be many cases where political signs are confiscated, moved, turned over, or covered with other propaganda and used for opposing campaign purposes. There are even situations where major theft or misuse has occurred, but such cases are difficult to prosecute because existing code is vague, determining whether or not certain misuses are a crime. I'm sure many of us here have experienced anger and frustration that occurs when campaign signs, your campaign signs, have been stolen or vandalized or on a statewide ballot campaign. This bill is simply designed to target theft or vandalism of political signs by clarifying that it is a crime for a person to knowingly take, possess, damage, reuse, or move any political signs without authorization from the owner of the signs. The bill also clarifies who would be exempt from this provision. The sponsor of the bill believes that by increasing public awareness such actions are a crime. This bill will be as much of a tool in prevention as it will be one of enforcement. The proposed amendments would further define who is exempt from the provisions of the bill as to avoid unintended consequences and only target gross violators with clear criminal intent. By adding criminal intent language, the bill has received broad bipartisan support through the Assembly, and I request an aye vote and would ask Mr. Garrick if he'd like to make a few comments.
Of course. Ms. Garrick.
With your permission.
Thank you, Mr. Chairman. First, I would like to compliment Mr. Miller for working so closely with our two offices, I should say, working closely together to merge what was my original bill, AB 491, which seems to be simultaneously we came up with the same good idea, one respectful of the First Amendment rights, one that on a personal note, I saw a lot of signs in the last campaign in a very heated and important statewide issue that were abused on both sides of the aisle, or not the aisle, but on both sides of the proposition in this case. And I saw individual signs that were abused. The idea came to me at the same time when add a little further personal note. When my airport was fogged in on December 4th, and I had to drive up here, and my wife and I drove up, and I actually saw and counted 54 signs along the freeway that said a $1,000 fine for littering. Now, my thought was, if there's a $1,000 fine for littering, what are the fines and how important is the First Amendment right of those people, whatever side you're on, whatever of a proposition or an individual? So with some work, I came up with a bill, and then Mr. Miller simultaneously was working on that. And with the good work of your Public Safety Committee staff, we were able to merge the two. And with that note, I think it's an excellent bill defending and protecting the First Amendment rights, creating a significant disincentive for individuals that are not respectful of that right, and urge an aye vote. Thank you.
Thank you, gentlemen, for bringing this forward. I think all of us who have been engaged in and familiar with the political process, we've seen all sorts of things that we would prefer not to have seen, and with little recourse for any sort of punishment for those who are doing these acts. So we're creating, as amended, and the amendments are on page 9 of the analysis, a wobblet. It can be charged either as infraction or misdemeanor.
Correct.
And subsequent penalties for second and repeated offenses. But I think you've crafted a good approach here, and one that's narrow, reasonable. We'll see if there is still any oppositional voice, but at the same time, we want to be respectful always of the First Amendment. But as Mr. Garrett points out, it works both ways. If you're printing a sign, you've got a First Amendment right to communicate that message without it being defaced or its intent completely changed. And at the same time, we want people who, for example, if I'm gifted a sign, I want to put it up in my house, and it says, the printed sign says they support someone, I want to change it to something else, I've got that right as well. So I think you're covering all bases here. So, those in support? Anyone wish to speak in support of AB 362? And anyone in opposition? Neutrality.
Neutrality. Francisco Labaco on behalf of the American Civil Liberties Union. I just come up here to thank the authors and staff for working on this bill. I think, as the bill is before you now, it minimizes the vagueness concerns and does minimize the unintended consequences of the original language of the bill. So with that, it's still content-based, but we're neutral.
Okay, thank you, Mr. Labaco. We appreciate that. And I want to thank both of the assemblymen for showing us how members can work together to get to a good end. Any comments or questions from the committee? Mr. Huff.
Yeah, this is a thorny issue. I've certainly dealt with numerous campaigns and being in local government where, you always have issues, at least in our community. And I found some communities do a better job of enforcement than others. But how do you handle a situation where an enthusiastic volunteer who has permission illegally places on a public pole, and another enthusiastic citizen comes and recognizes it's an illegal posting and takes it down, particularly on weekends or in the middle of the night when you don't have code enforcement officials. And they might have 5 or 10 of these in the back of their truck because they are doing a vigilante enforcement. Nothing, nefarious involved, but clearly illegally placed, even if with good intentions. And they are clearly being, a good Samaritan by trying to clean up something that was, they might even think there was no hostile intent. It was just ignorance of the law.
A couple things. I think that the language that we're proposing doesn't change the existing authority for prosecution. They can do it under existing law, under the existing circumstances. What this bill tends to do is further specify the language related to political sign theft. And in doing that, what we've done is we've created specific exemptions for, public property owners, private property owners that don't give permission for people to put signs on their property and they have the right to take it down. They would be exempt from this, and a whole definition of what an owner of a sign will be. So at the end of the day, it doesn't change the ability for the police or the DA to prosecute under existing law. They still have the authority under that circumstance to prosecute. What we've done is we've further defined what an owner is, and we've given those exemptions to local government agencies and property owners that haven't given permission. And at the end of the day, I think that it's not designed to prosecute a person that's pulling down one sign. It's designed for multiple defacing of signs, offenses, preventing free speech on multiple cases. There are a pallet of signs or multiple cases where they've been posted. So nothing really changes in that incidence. What we've given, though, is the DA more intent language to go after, instead of shoehorning a political sign theft into bland criminal law, we've given them more specific language to shoehorn it in.
Okay, thank you. You have a motion by Senator Benoit.
Senator Leno, I'm sorry. I did have a follow-up question.
Sure, Senator Hancock, then Senator Benoit.
To Senator Huffs, because I didn't hear the answer. This bill looks very good, as the amendments that you've taken. I really compliment the two of you on working together for one bill. We ought to see more of that. So it's really great. But what about the telephone pole issue? The telephone pole issue is signs, I believe, placed on telephone poles are illegally placed there and oftentimes are not taken down by police officers who have better things to do, but are taken down by volunteers of the other campaign. How does the whole misdemeanor, theft, etc. issue relate to that extremely common occurrence?
In any of those instances, this would not change any local ordinances. So the local ordinance would apply. I know in my city we created our own specific ordinance to address placement of political signs and real estate signs and all of that. So in all those cases, it would not divert any of the authority of local government.
Which, in other words, it's illegal and somebody takes them down. It's all up to local government. It is not impacted by this law in any way.
Exactly.
We're talking about signs voluntarily placed on a person's own property that get taken.
As one example, yes.
I'd also like to add that we do have a time frame that this is effective. And in some of my cities, for example, the city of Carlsbad itself also has a time frame that they actually allow you to put in the median divider on some of the major streets signs. So you'll see that, but they can only go in between a specific date and need to be out the day after the election or within that weekend. So again, the local ordinance would have an effect on the either installation or removal of the sign.
Thank you. Senator Benoit.
Thank you. I'd like to commend both the authors. I think the intent is extremely good. I think one of the concerns that's been raised is a legitimate one about the situation where the sign is being removed by the owner of the property or a representative of the owner of the property legitimately because it's his property and the sign shouldn't have been there in the first place. That representative, be it a volunteer of a campaign or a good Samaritan citizen who just doesn't like signs and knows that the owner doesn't allow signs on that property, were to remove it, they could be in jeopardy of the way this is worded. And I would suggest, and I'll support the bill, but offer the possibility that as you move forward, you may want to take a look at this, that in Section 1, where it says a person who takes a sign, what did you say? Excuse me one second. What's that? Oh, I'm sorry. I'm looking at the, I guess, old language. Let me see if it changes.
Nothing in this section shall preclude prosecution and punishment under any other provision of law, including but not limited to grand theft and vandalism.
Okay. I guess I'm looking at the first section that talks about who could remove it. Is there any possibility it would be worth including in there without authorization from the owner of the sign or signs or the property owner?
It's down here.
And is that included in your revised language?
Section C, under definition, the owner is a campaign for which the sign was created, a purchaser of the sign, a person who received a sign as a gift, a person who has given permission for the placement of a sign on his or her property. or a person in lawful possession of property who's...
Okay, I'll take a closer look at this after the hearing. I hope that's addressed.
That was our intent to address that. Placement, you might say illegal or inappropriate placement on private property, that the individual owning the property, taking down a sign would not obviously be breaking the law.
Okay, thank you.
And Senator Bone, it is addressed under Section D
of the new language.
Of
okay.
the new language, yes.
Thank you.
Thank you.
All right, we do have a motion.
And I'd also like to thank our colleague Fiona Ma, who is the joint author of the bill also.
Thank you for mentioning that. If there are no other questions before the committee, we will call the roll.
Senators Leno?
Aye.
Leno, aye. Benoit?
Aye.
Benoit, aye. Cedillo? Hancock? Hancock, aye. Huff?
Aye.
Huff, aye. Steinberg, right.
How many?
Oh, that's good. You might want to keep it open.
Yeah. Bill will be out. We're going to keep it open.
Thank you.
Thank you.
So
Thank you, Mr. Chairman.
Add on. Thank you. See, we have, I believe, our last two authors in the room. Assemblywoman Skinner, I think, was arriving just a little bit earlier, and then Assemblyman Liu. So, Assemblywoman, this is our item number 9 in your AB 999.
Thank you.
Welcome.
Thank you, Mr. Chair and members of the committee. Assembly Bill 999 provides a balanced system of incentives and discipline to allow youth in our state Department of Juvenile Justice facilities to earn based on their own successful participation in education programs, rehab programs, job training, or other programs that are offered by the DJJ system to earn earlier parole consideration through their successful participation in those. Excuse me, I'm wrong notes. AB 99 does not provide for early release, but it provides the youth the opportunity, as I indicated, to get an earlier parole consideration. It also eliminates the Department of Juvenile Justice's outdated use of time ads, which is a less than effective practice that contributes to the disproportionately long sentences that youth serve in California. Data from the state CDCR finds that a full third of the time spent in the DJJ facilities is due to time ads. I've been working with some of the opposition to the bill to add amendments to also deal with concerns that they to allow the youth to get half-day credit for good behavior. That credit could also be rescinded by the same officers for bad behavior. This is a cost savings measure. It is also a measure to motivate the youth in our system, and it is estimated to provide, if on average there's a 2-month, just a 2-month reduction in the average sentencing, we would save upwards to $65 million. I've with me now Sumaya, who is an attorney and state policy director for Books Not Bars, to sponsor the bill.
Very good. Welcome back.
Thank you. Again, I'm Sumaya Waheed with the Books Not Bars campaign of the Ella Baker Center for Human Rights. We're a statewide campaign representing families of incarcerated youth, primarily those in the State Division of Juvenile Justice. And it's those families who came to us with this bill idea, moms telling us, my child was sent to the DJJ for he was told he would spend 1 year, and it's now been 3 years. Time ads, on average, account for add an average year to each youth sentence, which is a large part of the reason why youth spend the longest time in the country in incarceration in California. So there's no evidence that they're working, despite spending $1,000 per year per youth. The DJJ has a 72% recidivism rate. So this bill will implement an incentive system to incentivize youth to participate in programs and earn some time credit so that they can earn an earlier parole hearing, which doesn't necessarily lead to release. It's always up to the parole board to decide whether the youth is ready. Other states such as Illinois and Iowa have had remarkable results by implementing incentives, and research indicates that it is a better way to encourage youth's positive behavior and reduce recidivism in the future. So we feel that the bill will lead to safety both within the institution and upon a youth's release. So we ask for your vote. Thank you.
Thank you, Ms. Wahi.
Heidi Strutt from Legal Services for Prisoners with Children. We support this bill and the principle that we're spending way too much money to lock up kids in these facilities that are not making our communities safer, and we urge you to support this bill.
Thank you, Ms. Strepp. Thank you for bringing the bill forward. I think that the important point to be underscored here is that a lot of these youth who are in the system have lived most of their lives being punished for every misstep that they take. And it becomes a whole way of dealing with the world and recognizing the world. No one's ever offered them anything if they did something right. And this really changes that dynamic significantly. I think it's a much wiser way to go without even taking note of the fact that we're putting youth deeper and deeper and deeper into our system with these add-ons from which they may never come back. And we know that we're not providing the legally mandated educational opportunities and requirements for these youth. They're not supposed to be in there to get punished. Law says that they're in there to get rehabilitated. These are not adult offenders. So to give them some incentive to find that which is good and positive within themselves, which we know is there, is a much more appropriate, thoughtful, and I think successful way to deal with them. So I commend your efforts here. Is there anyone here who wishes to speak in opposition to the bill? Please step forward. Mr. Salzillo.
I'm going to try this side this time, Mr.
Okay.
Chair. See. Mr. Chair and members, Corey Salzillo on behalf of the California District Attorneys Association. Our main concern with the bill is that we're kind of combining correctional models here. We've got an indeterminate system that we use for incarcerated or juveniles who are committed as wards, but we're adding to that features of determinate sentencing in terms of program time credits and good behavior credits. We'd also, I noted the author's statement regarding the amount of the credits, but the bill as it's currently written would give 1 day of credits for participating in a program or 1 day toward the moving up of the PCD, and then another half day for good behavior. So you're getting more than a day's credit for working in a program. The bill has also been amended to make it really easy to get the program time credits in terms of you don't actually have to be participating, and there are certain examples. But DJF has predominantly and historically been, as you said, for rehabilitation. And these are the sorts of things that are supposed to be happening anyway. And so if they're not, we would hope that they are, but if they're not, I'm concerned that by giving credits for things that aren't happening, we're just getting a little bit deeper. In the past 10 years, actually 13 years, the DJF population has decreased from over 10,000 to fewer than 1,700, leaving what we feel is the worst of the worst in the system. And so we're concerned that moving up parole consideration dates is dangerous considering the population that's left in DJF. Thank you.
Thank you, Mr. Salzillo. Others in opposition?
Hello, my name is Pamela Handel, Pam Handel. I am a teacher in DJJ. I'm a special education teacher. I work at the facility in Stockton known as CHAD in Chedurgian. And I also am a special education teacher. I work on what is known as the worst unit in CHAD. One side of the unit is a lockdown situation where students are either in a lockdown situation due to behaviors for a long time to learn about that behavior, try to work their way out, or a very short-term situation, maybe overnight. The other side is our long-term behavior modification program that works with our most mentally ill students that we have in that facility. The gentleman over here mentioned that our population has gone down. I've worked for the department for 19 years, and so I've seen it go from well over 16,000, I believe, to now around 1,600. And what we do, the students we do, and I call them students, excuse me, I'm a teacher. The students we have left in DJJ are the ones with the most mental health needs. I'm working with students in my particular facility with the most needs. I work with students at their cell door, or I encourage them in some way to try to come out and work with me individually. As I looked at the initial bill that was written, we started to come up with some concept. Well, I looked at it as if I was sitting inside this institution every day, and I thought to myself, have they actually really come inside our facilities in the last few years? So we started talking a little bit about the concerns. There was some original language that talked about good time, even if they had a mental health reason that they couldn't participate in anything, that they would go ahead and get the good time. Just within the last few days, the authors have talked about adding in leaving that kind of consideration about good time up to the mental health treatment staff. That would be our clinical psychologists or our psychiatrists. They would be able to determine if the student was making enough treatment movement that they would be allowed some good time, even if they weren't coming to school or something like that. As an educator and advocate for students, I really like to see the concept of not really reward, but acknowledgement of participation in education. A few years ago, we had the whole no diploma, no parole. I don't exactly know what happened to that, but it either died a quiet death or mysteriously disappeared. But as an educator, I like to see something that says not necessarily graduation, but participation, fully and completely in education, in treatment, because that's rehabilitation. Even if they don't go out with a diploma or GED, they have gotten more credits, improved skills, moved towards passage of the high school exit exam, learned a trade, that kind of thing. So that actually is what makes them successful. And we also teach them, hopefully they learn, how to go and complete that education when they are on parole. So there are a lot of things that they have done in the last few days that I particularly as an educator like. I also am an SEIU representative for the Service Employees International Union that represents teachers in DJJ and DAI. And I think that we also like it also because our instructors have always stood up and advocated for our students, and we would like to see this bill, if there's a few more things that can happen here that we've been talking about even this morning, we would like to see this bill possibly go through, maybe with a little bit more discussion about the half day. That was something I didn't even hear about until just now. But with the ability, I did want to say something about time eds. For those who do not work in DJJ, and the gentleman over here mentioned that there are two separate departments, and DJJ looks at time ads a little bit differently maybe than some people think. Time ads are there in place, I think, for a reason. Over the years, I've seen lots of young men, and I've only worked with the young men. I haven't worked at Ventura with young ladies. But I've seen lots of young men come in, and they have maybe come in at 14 or 15 years old, and I'm working with them at about 17, 18, 19, maybe. And they will tell me a lot of times, well, why did you do these things that you did, these fights you got into, and basically these crimes that you committed while you were here? And their answer is almost universally is, because I hadn't yet learned that I shouldn't do those things. I hadn't learned the skills that I now know that I shouldn't have done those little stupid things. I'm here because I was too childish or immature. Now I am paraphrasing that a little bit. They usually lose a little slang when they say those things. But I think that the time ads are really there because we reparent them. We bring them in, we reparent them. We work on the skills that mom and dad tried to or grandparents tried to and didn't quite work because they weren't quite there yet. And that's why the time ads have always been pretty good. So rather than throwing out the baby with the bathwater, the time meds I think should still be there, and the time cuts that they're talking about, the good time, if you will, I think that's really good. So thank you.
Thank you for sharing your experience with us, and thank you for all the important work you're doing on the inside.
Helen Roth Dowden with SEIU. Just to say, we're trying to work on amendments. You know, we're not for something for nothing. We don't think that that's going to help students by giving them credit if they haven't gone to school. If they actually are doing things, we are very supportive of doing positive incentives. So we will work with the author and see if we can come up with amendments that we can all agree to.
Thank you. And Ms. Skinner, do you have any response to some of the critique?
Yes, we have been working with, as I mentioned, with SEIU to address some of their concerns, to basically ensure that, and I also want to be very clear that we're not talking about time reduction. There's nothing in this bill that guarantees any youth in the facility a time reduction. The bill only allows for, if they, through their own effort and discipline, participate successfully in the programs, as our teacher has mentioned, that they would have consideration for an earlier parole hearing. If their record in that parole hearing shows that they otherwise continue to be serious threat to society or disciplinary problems, they will not get a release. So this just gives them, as you pointed out, Senator Leno, some incentive to participate in the excellent programs that DJJ offers, for which they have no incentive now to participate. So through their own effort and discipline, if they do so, at least they can see some potential light at the end of the tunnel. But we are working with SEIU to try to we submitted language to us today that we are looking at and discussing, and I'm hopeful, very hopeful, that we would be able to meet a resolution that would have SEIU support the bill or at least be neutral.
Very good. Well, I trust the bill is in good hands with you.
Thank you.
All right. Any other comments or questions from the committee? Senator Huff.
Yeah, I actually agree with a lot of the comments made by the witnesses here that are trying to work with the author, and I would certainly encourage you to move in that direction. My mom taught in the juvenile hall for over 20 years, and she would come home and talk about how she'd have to send a kid into lockup. And you got very few levers on them, but certainly adding time is one of those for the chronic that just can't get reparented properly, and that is a good term because that's often what's happening. These behaviors didn't get established in a short period of time. They don't get extinguished in a short period of time. And there's very few levers you have on somebody that's calloused and, just bucking the system everywhere there is. So I'm not going to support the bill today, but I may be able to support it if you can incorporate some of the things that they're looking for.
Thank you, Senator. We have a motion by Senator Hancock, and if you'd like to close.
I think that we've discussed the issues pretty thoroughly, and I respectfully ask for your aye vote.
Very good. We'll call the roll.
Senators Leno?
Aye.
Leno, aye. Benoit, Cedillo, Hancock? Aye. Hancock, aye. Huff? No. Huff, no. Steinberg, right.
We are missing a few members, so we'll place that on call. Great. And take it up a little bit later.
Thank you.
Thank you. Members, our last bill of the day is item number 11, Assemblyman Liu's AB 1122. Welcome, Assemblyman.
Okay. Thank you, Mr. Chair and Senators. AB 1122 will help prevent animal cruelty by preserving quality standards for all pet sales throughout the state. Puppy mills and backyard breeders currently use parking lots and roadsides as temporary vending locations because regular pet stores will not take their animals. Because current health and safety regulations do not apply to animal sales at these locations, many young animals are being sold that are often mistreated, ill, or diseased. There's also no recourse if a consumer purchases a sick animal at one of these venues because there's no way to track the seller. This problem has become so prevalent that certain counties have already adopted this ban. This bill is based on a law in Arizona, and it's sponsored by the California Animal Association and the ASPCA. I have witnesses here in support.
Thank you, Assemblyman. Those in support?
Mr. Chair, Committee, I'm Officer Tyron McDaniel. I'm a humane officer for the Los Angeles SPCA. During my 6 years of experience, I have pursued animal cruelty cases and responded to numerous complaints on the streets of Los Angeles. The sale of puppies on the street corners is rampant in my area, and the problems stemming from these sales are many. My organization receives approximately 2 to 3 complaints each week, and the most recent complaint came to us from the Los Angeles Police Department. A man was selling puppies on the street, but at his home I observed 10 dogs in the yard without food, water. The dog was tethered on a short lead. It was in unsanitary conditions. I have pictures here, if the committee would like to see them, of a female emaciated pit bull. The man was breeding the puppies and selling them for $250. My office routinely receives complaints from the victims after they have purchased animals in the parking lot or along the street corners, only to find that the animal is sick or diseased. It is terribly frustrating because the buyers have no recourses because they do not know where the seller actually lives. Many sellers use disposable cell phones so they can change their numbers. Because California law allows the sale of these animals in temporary venues, the hands of officials like myself are often tied. The result is that the problem persists. However, AB 1122 provides a desperately needed solution. The burden is on us to prevent animal cruelty and to ensure the basic health and welfare of animals and consumers. We have the training, we have the experience. What we're lacking is the tools with which to do our job. My organization supports AB 1122, and I hope you do likewise. Thank you.
Thank you, Mr. McDaniel.
Thank you, sir.
Good morning, Mr. Chair, members of the committee. I'm Barbara Schmitz. I'm here on behalf of the California Animal Association and our 1.5 million California members. We're co-sponsors of the bill. The other co-sponsor of the bill is the State Humane Association, which represents investigators as well as animal control officers statewide. Basically, what I want to do is just let you know that this bill takes some existing ordinances and expands it statewide so that we're trying to be consistent and fill in those gaps in law. And I'm happy to go ahead and answer questions. Thanks so much. We ask for your support.
Thank you. Anyone else in support?
Mr. Chairman, members, Dan Filisato on behalf of the Los Angeles District Attorney's Office. We think this bill is important. The sale of animals on the roadside, our office gets lots of complaints that those animals turn out not to be as advertised. They quite frequently have health problems and consumers feel cheated. They report to our office. We would like to end this practice. And this ordinance or this law models very closely the LA County ordinance, so we're in support. Thank you.
Thank you, sir.
Hi, Mr. Chair and members. Jennifer Fearing on behalf of the Humane Society of the United States, also a member of the California Animal Association, and we're in strong support.
Thank you.
Thanks.
Dave Middlesworth, People for the Ethical Treatment of Animals, also a member of CAA, in support.
Thank you, sir.
Nicole Forsyth with United Animal Nations in support.
Thank you, Ms. Forsyth.
Jill Buckley on behalf of the American Society for the Prevention of Cruelty to Animals in support. Thank you.
Thank you, Ms. Buckley.
Nicole Paquette on behalf of Born Free USA in support.
Thank you.
Virginia Handley Popak in support.
Thank you, Ms. Handley.
Susan Trout on behalf of Born Free USA, support.
Thank you.
Mr. Chairman, members, Zeke Grader at the Pacific Coast Federation of Fishermen's Associations. We found out about this bill yesterday and quickly read through it and had some concerns because, among other things, it could apply to the sale off the vessels of live animals such as crab.
Just one moment, please. We're going to just make sure there's anyone else here who's in support of the bill.
No, this isn't. I'm just saying, let me just say this is in support.
Go right ahead.
I contacted the author's office immediately and suggested some language that would take care of the problem of off the vessel sales of live seafood, such as crab and clams and that, and they've agreed to take it. So with that, we're in support.
That's good to know. Thank you. So that was not the intent of the bill. And anybody else in support? Opposition?
morning, Mr. Chairman. My name is Bill Hemby. I represent the organization called PetPack, which is represents 65,000 pet owners and over 800 dog and cat clubs in California and outside of the state. We're opposed to AB 1122 because it will have a devastating impact on accepted and established practices at animal shows, including dog and cat shows and dog and cat displays. AB 1122 will impact advertising, restraint of trade, and free speech issues at our dog shows and cat shows and other animal shows. We're particularly concerned over the ability of purebred dog and cat owners, breeders, exhibitors, trainers, and breeders of hunting dogs, herding dogs, working and farm dogs, public safety dogs, and guard dogs, to display or even to talk about the sale of animals at these sporting events. This would also affect donation by local dog clubs to law enforcement of police dogs that would be working in the protection of the public. At our dog shows, which are held at public parks, county parks, you have possibly over 2,000 dogs entered at each of these shows. These shows occur 2 to 3 times a week, every week around the state of California, and there are literally hundreds of thousands of pet owners involved in this, and millions of pet owners who go to these shows to talk to breeders about care and treatment of their animals and possibly purchase of pets or future purchase of pets. Under AB 1122, any discussion about a pet purchase or future purchase would be illegal, would be a crime. The exhibitors themselves and set up at the dog show, every one of these shows has public streets, public right-of-ways, so they're set up right on a public street and a public right-of-way and a public park, so they would be in violation. They put out what we call an exercise pen. In the pens, which are open and protected, are dogs that are going to be shown as well as puppies so that the breeders can show off their progeny. And invariably, breeders are approached by many citizens who are fascinated by the particular animal that they've bred and may have been taking 20 years and putting together this breeding. And if they ask them about, I really like that dog, do you have a puppy? And if I say, no, I don't, but the lady across does have puppies on the ground, go talk to her, and that person does, and they say, yes, we do have a puppy, and would you be only interested in selling that puppy? They're in violation of law. That's a criminal offense. So, and this is going to impact hundreds of thousands of dog owners of purebred dogs and cats. Now, these are, in my own humble opinion, these are the best dogs and cats bred in the world, bar none. California breeds the best dogs and cats in the world. When a person wants to buy an animal at a dog show, which is not the function of the show. The function of the show is to show off your dog as it applies to the procedure of the animal. You have an opportunity to talk to the breeder. You get a chance to see the dam or the sire. You have an opportunity to talk about the breeding process. You see exactly what you're going to get. You talk about contractual arrangements, about ethical conditions, about responsibilities of pet owners, about the health of those animals. So it's a very visible and very open discussion. There's nothing hidden about this because the animals are right there. You know what you're going to get, and you can proceed with that sale if you deem to do so. We have talked to the author's staff, and we've talked to the proponents, and we've asked them if they would consider amending the bill so that we would have animals shown at these animal shows excluded. Now, it was also PetPack, my organization, who brought it to the attention of the author's office that this bill would have impacted 4-H clubs, which they did not realize at the time, and that was excluded. It was also my letter and my discussion with the gentleman from the fisheries that brought up the fact that this would impact live crabs sold at Fisherman's Wharf, and live animals, crab and horses sold in public auctions. Just additionally, just this last weekend, the University of California had an auction and sale of live horses that were raised by the university. These are not horses that are in consignment that are exempted from the bill. These are horses that are raised and cared for at UC Davis. This would be a violation of this bill and be a violation of law.
Mr. Hambly, I'm going to take some other witnesses.
Yes, I'm sorry.
No, you don't have to apologize. We thank you because you've been very attentive. You've made the bill better to date, and I think we're going to make the bill better yet. So,
thank you, sir.
And that's with thanks to you. So others in opposition.
Chairman Leno, thank you. Diane Amble from San Francisco, California Animal Voters Alliance Director of San Francisco, and We the People Pets. AB 1122 lists as animal abuse the sale of live animals. This sets a precedence that the actual sale of live animals could be animal abuse or is animal abuse, and it creates a new crime. Is it responsible to be creating new crimes and therefore new criminals when the state is now releasing felons from state prisons into local jails and into the populace? Our prison population is huge. I don't need to tell you that. A burden on the state and ultimately on taxpayers. AB 1122 also violates freedom of assembly. It forces people to not avail themselves of meeting in public. This is a public safety issue. Only one needs to consider the rise in home robberies as people allow strangers to their homes to buy or sell, for instance, a car or an animal. There was a much publicized armed robbery of a family selling a litter of puppies caught on their home security cameras. You probably saw that. AB 1122 would also face a legal challenge due to 3 California precedent cases in which Ventura County and the City of Los Angeles tried to prohibit for sale signs on vehicles in public streets, as well as limit yard sales. The defendants prevailed in all 3 cases, and it was shown to violate the right to sell property, and it also limited commerce. We also have an issue with the unconstitutional and illegal and fraudulent manner in which law enforcement power is being given to humane officers, and I don't mean our county and city animal control officers. I mean private corporations such as SPCA of LA that was right here today giving testimony. In fact, today, the court in the city of Los Angeles is giving a woman's home, a handicapped woman's home, to the SPCA of LA it was a rescue person. They took her dog. She fought them for 2 years. They levied $800,000 worth of fines against her, and they're taking her home today. And that was a misdemeanor. The way that they got this humane powers, these humane officers, even though they're not peace officers, in this particular case, for instance, the warrant was illegal. It was given to a gentleman just like the one that was here.
Ask if you could just focus on the bill that's before us.
Well, what it does is it continues to expand that power to humane officers who are not our local government, to private corporations, and they can abuse it, and that's what we are also very concerned with. Thank you.
Okay, thank you. And just to say we are in this committee like-minded with you, so I just want to correct your misperception. This bill will not exacerbate our prison overcrowding situation. This bill does not send anybody to state prison.
Well, not to state prison, but to jail. And we are sending our prisoners from state prison into jails, and we need that place for those kind of criminals, not people who right now are not criminals, they're regular citizens. Okay. So that's my precept.
Very good.
Thank you, sir.
Others in opposition?
Mr. Chair, members, my name is Chuck Bridges. I'm an AKC judge, and I'm here today representing the California Federation of Dog Clubs, the Cha-Cha Fanciers Association of Southern California, and the Greyhound Club of Northern California. Section 597 of the Penal Code and its various subsections already criminalize a range of abusive activities envisioned by AB 1122. In other words, enforcement agencies currently have the authority to pursue animal abuse and animal abusers in the venues without further legislative action. AB 1122 does not, however, criminalize additional abusive activities. It erroneously assumes that the mere sale or offering for sale of animals in a variety of public venues continues animal abuse. This assumption flies in the face of our common experience. I pass this sign every day, which it says goats for sale in rural Alameda County every day on my way to work. Does this offering for sale really constitute an abusive activity that should be outlawed in California? Further, the sale of animals in public spaces has traditionally provided an accessible, low-cost marketplace where excess or unwanted animals can be placed with new owners. Without such a marketplace, these animals might very well be destroyed, surrendered to animal shelters, or abandoned by their owners, adding further to animal suffering and burdening our local shelters. For these reasons, we would respectfully ask for a no vote.
Thank you, sir. In opposition.
Yes. Forenza Pini, San Francisco, California, president of Feline Friends International Cat Club. AB 1122 will impede rescue efforts as many rescue animals are transferred in just such a manner as is prohibited by AB 1122 by regular citizens that are not registered charities. Thank you.
Thank you. Sir, we've had full debate. If you could keep your comments very succinct, please.
I will try to, yes, sir.
No, if you could please
I will.
Very succinct.
My name is Roland Christo. I represent the American Society of Aviculture, the Model Avicultural Plan, Advocates for Bird Conservation, National Finch and Softbill Society. Our main issues here are in this hobby of raising exotic birds and even pigeons, racing pigeons or anything else. You may make a transaction with somebody in San Francisco. You don't want to drive to San Francisco, so you're going to meet in Vacaville. You meet at a Denny's and you trade the birds. This law would make you against the law. There are lots of organizations, local clubs, especially in L.A., that during the good weather will have a bird mart outside in a park or in a parking lot. I mean, they get the local jurisdiction's permission. This law should be left up to local jurisdictions. Both the reasons they give for this law, animal control can go anywhere. They can come onto my private property if they have just cause to believe that there's a problem. The 8-week-old puppy thing, there is a law that covers that. It was passed 2 years ago, if I'm not mistaken. It's 597 Penal Code. Nobody in this state can sell a puppy under 8 weeks of age unless they have a signed certificate from a vet. Thank you, sir.
Thank you, sir. Appreciate your witness today.
Yes, hi. I'm Sarah Piepenberg. I raise and breed birds. I also have pet birds. I belong to 3 bird clubs, 2 of which have rescue groups, and I participate with both of them. We have times where we cannot go to the person's house and pick up the bird or in cage or whatever they have available, so we meet them. Maybe in a grocery store parking lot or a McDonald's parking lot, somewhere where it's convenient for both of us. If we keep doing that and this bill is passed, we're going to jail or we're going to be paying money all the time. We're in this to keep these birds existing, keep their breeds going. If we don't do it, who's going to? We need these birds in our lives so our children and their children can enjoy them as much as we do.
Thank you.
Thank you.
Hi, I'm Nancy Klingon. I'm the president of Foothill Bird Fanciers. I also run an adoption program where we rescue birds. I, too, belong to several clubs, and I work with Adoption Committee and the other clubs. We need these programs. When somebody has to give up their bird, I've had people say, well, if you don't take it, I'll let it go. We cannot allow that to happen. With this law, that will happen because we're not going to purposely go out and break the law just, because we feel that it's the right thing to do. We're going to get in trouble. We cannot have that law pass. It's not right. We have the right, and we take very good care of our animals, and we want the best for them.
Thank you, Ms.
Thank
Klingon.
you.
We're going to conclude soon, so if you could give your name and identification, please.
Mary Mejia, I am former president of Capital City Bird Society and a member of several bird clubs. In opposition to the bill primarily because it does criminalize the sale of animals and considered animal abuse. That's one of the main things. Also participate in rescues and feel that it's unnecessary. We do have the laws in order to protect the animals. We just need for them to use them. Thank you.
Thank you very much. So, in opposition, name and any identifying organization.
Sonia Walker. I'm with Foothill Bird Club and a couple others, and I want to oppose the bill.
Okay. Thank you very much.
Oh, I'm Teresa Hare. I'm the president of the Capital City Bird Society. And I wanted to say that this bill has seemed to be characterized as a puppy mill bill. And I want to point out that exotic birds won't breed in filthy or bad conditions, crowded conditions, without food or water. They just don't breed that way. I don't know why all birds can't just be exempted from this bill. I have also placed personally thousands of birds rescued into homes where they are treated better. If there's no way to rescue these birds, then they do get abused.
Thank you for the suggestion. Thank you.
I'm John York. I'm with the American Federation of Herpetoculture and American Society of Aviculture and a few other groups. I would just ask the committee to apply the same standard as they did to a few bills back here and ask what this bill is actually doing that our local ordinances and humane societies and so forth are not already dealing with, and actually have the ability to enforce and, as far as we know, do well.
Thank you, Mr. York. Anybody else wish to offer a name and organization in opposition to the bill? All right. There may be comments, questions from the committee. I think a lot of the opposition, Assemblyman, has some merit to it. And I want to give you an opportunity, if briefly. We have a caucus at 12 o'clock, to which we are late. But with regard to some of the ideas of exemption, dog shows, horse shows, possibility of exempting birds altogether, because I think some of the comments made have merit to it. I was going to suggest that we could probably tack on some wording that we would submit to Ledge Council as amendments as it leaves committee today. I think it's a little more complex than that, so I'm going to suggest that we take a week and get it right as it's moving forward. But I want to allow you the opportunity to comment some of the oppositional voices.
No, thank you. So this bill doesn't apply to rescues, transfers, adoptions. I also don't believe it applies to dog shows or cat shows, but we're happy to put in additional clarifying language. Okay. It's based on ordinances that counties have already adopted, such as the City of L.A., Sacramento, Kern County, as well as a state law in Arizona. But more than happy to work with the committee, get additional clarifying language so that all the stakeholders are comfortable that the bill does not apply to them. Because in a lot of these situations, I don't believe it actually applies to them, but we can make language more clear.
Okay, very good.
So I'm happy to do that if it's the will of the chair.
That's great. I'm sure we can find the common ground that's necessary. I'm in support of what you're trying to do here, but again, I want to be respectful of the voices raised, and I think there is some merit.
Sure, and we'll work with the committee to get the clarifying language.
Wonderful. Right. And we'll make sure that we're very respectful of deadlines, so this is not putting your bill at any risk.
Great. Thank you.
Any other questions or comments from the committee? Senator Huff.
Real quickly, I have a little. I appreciate we're tightening it up some, and that's good. I've got a lot of correspondence on this issue, pro and con. Clearly, we deal with animals. You hit people, where they live. One of the concerns I have is giving authority to animal control officers and humane officers on this. Do you know the training that they receive that qualifies them for this?
We have an officer here,
Mr. McDaniel.
Yeah.
Sir, I can speak on that, Senator Huff. My training comes from, I'm a graduate of the Rio Hondo Police Academy, so I'm trained as our police department is trained. Not only that, I went to the Humane Academy. I had more than 1,000 hours worth of training with a field officer before I was even signed off to actually go and do cases. I probably did, before I was even signed off on SERV, probably more than 2,000 cases or complaints, whatever you want to call them, when it came to animal cruelty.
Are all? I mean, you have extensive training, but are all officers that can carry a badge with that title? Do they go through the same type of training? Is there any systematic standard?
Yes, I'm going to say that our humane officers at the organization that I work for, all our officers are trained in that manner.
But that doesn't speak statewide.
It doesn't speak statewide.
And the reason I bring this up is, I was in a contract city. We actually contracted with Humane Society to provide animal control.
Yes,
but I had experience with some that were deputies for the purpose of, getting fees, that wore a badge, wore a uniform, had everything that, someone like yourself had, zero training. And my concern is that this language is broad enough that it encompasses anybody like that. And I have concern of giving those police powers, and I think that, there's a witness up here that were talking about that. So just perhaps we can look at that during the next week. I don't want to take more committee time because I know that, you guys have a little time late.
That's okay. I appreciate the comments, Senator.
Okay.
If there are no other questions or comments from the committee, we will set off to work and get this bill right.
Thank you.
Thank you for working with us. And thank you for all the testimony today, both pro and con, especially the con. I think you've helped us improve the bill. So we are going to lift calls now, members.
Some of these don't have any motion because we were working on the subcommittee, so you'll see because there will be no vote.
Okay. We're going to take them in order of presentation, starting with item number 2, which is AB 27 by Assemblymember Jeffries. If we could have a motion, please. We have a motion, and we will call the roll.
Senators Leno?
Aye.
Leno, aye. Benoit?
Aye.
Benoit, aye. Cedillo?
Aye.
Cedillo, aye. Hancock? Huff?
Aye.
Huff, aye. Steinberg, Wright?
Aye.
Wright, aye.
And before we move forward, do we know where Senator Hancock is? Is she in? She's not in caucus? Senator Hancock, if you could please return to the committee room so we don't have to go through this a second time. So we will put that bill on call out of respect for Senator Hancock. Otherwise, it is out. Item number 6, Assemblyman Amiano's AB 358. And we need a motion for that. Moved by the chair. And we'll call the roll.
Senators Leno?
Aye.
Leno, aye. Benoit?
No.
Benoit, no. Cedillo?
Aye.
Cedillo, aye. Hancock? Huff?
No.
Huff, no. Steinberg, Wright?
Right, aye.
Wright, aye.
So we have 3 ayes, 2 noes. We will place that on call. Item number 4, Assemblyman Portantino's AB 169. And we need a motion on that.
So moved.
Thank you. Call the roll.
Senators Leno?
Aye.
Leno, aye. Benoit?
Aye.
Benoit, aye. Cedillo?
Aye.
Cedillo, aye. Hancock? Huff?
Aye.
Huff, aye. Steinberg? Wright?
Aye.
Wright, aye.
We have 5 ayes, no noes. That bill will be out. We'll put it back on call. Item number 3, AB 61 by Assemblyman Nava. There was a motion to pass the bill. It is on call. The chair has voted no. And again, I'd like to, if the bill does not leave committee, offer the author reconsideration because I think there's a way to narrow the bill that I could conceivably support. But I just put that out there as we continue the roll call. So the chair was no. We'll lift the call.
Senators Benoit?
Aye.
Benoit, aye. Cedillo? Hancock was no. Huff?
Aye.
Huff, aye. Steinberg, Wright?
No.
Wright, no.
So there are 2 ayes, 3 noes. That bill will fail. And without objection from the committee, reconsideration is given to the author. Item number 5, AB 316 by Assemblyman Solorio. We will lift the call. The chair voted aye.
Senator Benoit?
Aye.
Benoit, aye. Cedillo?
Item number 5, AB 316.
Senator Cedillo?
Aye.
Cedillo, aye. Huff?
Aye.
Huff, aye. Steinberg? Wright?
Aye.
Wright, aye.
6 ayes. And that is as amended. And that bill is out. Item number 10, AB 1015 by Senator Torlakson is going to be put over to the next meeting so we can consider July 7th.
Vote only on the 7th.
Vote only on the 7th. We're considering an additional amendment. Moves us to item number 1 by Senator Yee, SCR 40. We'll lift the call. The chair voted aye.
Absent. Senator Cedillo?
Aye.
Cedillo, aye. Steinberg? Wright?
Aye.
Wright, aye.
And that bill is out 4-0. Item number 7, AB 362 by Assembly Members Miller and Garrick. We'll lift the call. The chair voted aye.
And that's as amended.
And that is as amended.
Can I ask a question? I'm sorry.
Sure.
What was the amendment?
The amendment was Garrick drops his bill. He's joining.
It's all on page 9 of the analysis, whole page of amendments.
Thank you.
We will lift the call.
Senator Cedillo? Cedillo, aye. Cedillo, aye. Steinberg? Wright?
Aye.
Wright, aye.
That bill is out 6-0. Item number 9, Assemblywoman Skinner's AB 999. Chair voted aye. We'll lift the call.
Senators Benoit?
No.
Benoit, no. Cedillo? Cedillo, aye. Steinberg? Wright?
Aye.
Wright, aye.
That bill is out 4-2. And then we've just put over Assemblyman Liu's bill, item 11, AB 1122.
And you left these open for Senator Hancock.
And we've left the other bills open for Senator Hancock, who I hope will be here. She's here.
She's
Great.
here.
Thank you. We will then, members, if you voted, thank you very much. Otherwise, we'll go back to item number 2 and lift the call.
Senator Hancock? Hancock, aye.
That bill is out 6-0. Item number 6, lift the call, please. Assemblyman Amiano's AB 358.
Senators Hancock? Hancock, aye. Steinberg?
That bill is out 4-2. Item number 4, AB 169 by Assemblyman Portantino.
Senators Hancock? Hancock, aye.
That bill is out 6-0.
And that's it. That's it.
Our work is completed, committee members. Thank you very much. We are adjourned.